Good morning, everyone, and thank you so much for being here. My name is Kiera Flannery, and I'm the editor-in-chief of the Widener Commonwealth Law Review. I'm honored and excited to welcome you all to our annual spring symposium entitled From 1776 to Today, The Evolution of Dissent in American Law. In honor of the 250th anniversary of the Declaration of Independence, our goal for this event is to highlight one of the bedrock principles that underlies our nation, the enduring idea of dissent. From the United States founding to the present day, dissent has served as a safeguard of our democracy, ensuring that citizens retain the power to question authority and advocate for a more just society. Exercising this right responsibly, however, requires that we remain informed, engaged, and respectful of differing opinions. We are fortunate to have this forum to facilitate these important conversations, and even more fortunate to be joined today by distinguished scholars and jurists who will help guide us through these principles. Before we begin, there are several people I would like to express my gratitude to, as today would not be possible without them. First, I would like to thank our Law Review advisor, Professor Kearney, for her unwavering support this past year. Professor Kearney has been an incredible mentor throughout all of the Law Review's endeavors and was instrumental in bringing this day from an idea to a reality, nearly a year in the making. Thank you to all of our speakers, many of whom have traveled a long way to partake in this symposium. I would also like to thank Brian Fernbaugh and Robert Brown for their IT support, as well as Bob Dolbin, our Director of Maintenance. You all truly keep this school running. Thank you to our moderators, Professor Family, Professor Lee, and Professor Power, for coordinating the panels you will hear today. Thank you to Dean Ackery, Dean Teplitz, Paula Heider, Stephanie Angerer, Val Hawkins, Shannon Whitson, and John McCafferty. They are an amazing administrative staff who supported us in our advertising, catering, and overall event planning. I am, of course, eternally grateful to the Law Review Board and members who are here today in support of this event. It's been my honor to work alongside you this past year. Lastly, I would like to thank Dean Cummings for his support of the Law Review and its dedication to continued growth. With that being said, please join me in welcoming Dean Cummings.
I could not be more delighted to welcome you to this fabulous law school, Widener Law Commonwealth, for what is a cutting-edge symposium topic. Welcome. I am very grateful to Kiera Flannery. She knocked out all of the thank yous that I was going to mention. So the last thank you that must be mentioned is Kiera Flannery. When I started as dean, Kiera was a fresh-faced 2L. I remember calling her into my office and having a conversation about how well I felt like she'd done and the future that she could have as an attorney. And it's been really fun to watch Kiera grow up and become a fabulous editor-in-chief. And last night at the Law Review dinner, I was asking Ray Yoder who the symposium chair was. She said, that's Kiera Flannery, the editor-in-chief and the symposium editor of the Law Review. So I think that all of the thank yous that she mentioned are totally appropriate, but we need to pay tribute to Kiera today. I can't wait to see what the future holds for Kiera Flannery as a practicing attorney. Special thanks also to Mary Kate Kearney for her leadership, and to all of you in the Law Review in particular for being here. Okay, so I wanted to talk for just a couple of minutes about why we're here today. When I heard the topic, proposal, the evolution of dissent in American law, I was really excited. One of the things that's critically important to me, and I hope to all of us, is the fact that in this country, we are free to express ourselves how we see fit. And if that's in dissent, that's welcomed. We are a law school that welcomes all voices, voices of the majority, voices of the minority, voices of discontent, And one of the things that's been true in American history is that dissent in American law has been favored, respected, appreciated, and I couldn't be more excited for this topic today. It's current, cutting edge, and I wanted to spend a few minutes talking about my personal judicial hero, known often as the Great Dissenter, and we even have one of our speakers as an expert in the dissenting opinions of Thurgood Marshall. So I went to Howard University School of Law. When I walked into those doorways, those of you that are students think of your first day walking into law school for the first time. As I walked into the doorways of Howard University School of Law, there was a quote on the wall from Charles Hamilton Houston, the mentor of Thurgood Marshall, the architect of the Brown versus Board of Education series of cases. And Charles Hamilton Houston said, and I invite you students to think about this, a lawyer is either a social engineer or a parasite on society. So you have two choices, guys. You can be a social engineer. You can decide to use your law degree to change the world, your communities, your states, your regions for good, or you can just, parasite on society. Thurgood Marshall took that notion to heart, and as he graduated from Howard University School of Law, he became the quarterback of the Brown versus Board of Education series of cases that brought separate but equal down and equality to a place of relevance here in the United States. I wanted to share with you that when I was in law school a few decades ago, Sandra Day O'Connor, then a Supreme Court justice, came to the law school at Howard and talked to us. And she knew how much we at Howard University Law School loved and revered Thurgood Marshall. And she told us that when he was a justice together with her on the Supreme Court, that often under the Rehnquist court, the justices would, after an oral argument, sit around their table and sort of rapid fire talk about, this is how this decision should come out, let's do a quick vote, this is the majority opinion writer based on seniority. And she said that it would always get to Thurgood Marshall's turn. He would lean back in his chair, light up his cigar, which I guess, back then you could do in the Supreme Court chambers, and he would slow the court down, and he would tell a story. And he would often tell his judges, and remember, Sandra Day O'Connor was the first woman. Thurgood Marshall was the first African-American on the Supreme Court, so the rest were white male, probably traditional. But he would sit back and tell a story about what it was like to be a black man in America. And he would say, I need you to understand that these litigants in this case, this isn't just about the issue. This isn't just about the law as we're going to pronounce it. This is about human beings and lives, and they have to be important to us as we consider the outcomes of these cases and what they're going to mean for all of the people that will live under these laws as we adopt them going forward. So it's no question, right? It's no surprise that he was in the majority during the Warren Court era for all of the rights expanding cases that happened during the Warren Court. And it's also no surprise that as the court became more conservative under Warren Burger and Chief Justice William Rehnquist, that he became the great dissenter. As all of these sort of opinions that started dialing back what he felt like were human liberties and civil rights opinions, he couldn't abide them, and so became this great dissenter. Respected, appreciated, and the thing that I wanted to end with is that oftentimes in American law, the dissenting opinion just needs one vote for it to become the majority. And so throughout our history, oftentimes dissenting opinions have especially the horrible opinions, the Plessy versus Fergusons and the Dred Scotts, those dissents eventually become the majority as our law, as developed in our country, tries to get to the right place, which is equality for everybody, equal opportunity for all. And that's what we're here to talk about today. The great evolution of dissent in American law, and it couldn't be at a better school than Widener Commonwealth, where we prize these values, respect them. I am so excited for this lineup today. So with no further ado, enjoy what is to come. Thank you all for being here.
Good morning. My name is Professor Jill Family. I'm a professor here at the law school, although I think I know most of you, and I want to welcome, I see a lot of my civil procedure students here, so a special shout out to them. It is my great honor to be moderating this first panel, kicking off this amazing symposium. And so I'm just going to briefly introduce our two speakers, and then each speaker will have about 20 minutes to speak, and then we'll have some time for questions. So we'll start off with Professor Chauvin. Noah Chauvin is an associate professor of law at the University of Oklahoma College of Law. He writes and teaches in the area of First Amendment law, surveillance law, and the production of legal scholarship. Prior to joining the College of Law, and this is how we know the professor, he was on the faculty here at Widener University Commonwealth Law School. He also served as counsel in the Liberty and National Security Program at the Brenner Center for Justice and an attorney advisor in the Intelligence Law Division of the U.S. Department of Homeland Security's Office of the General Counsel. So welcome back. Amy Gaudion is an associate professor of law and founder of Dickinson Law's annual cyberspace simulation with the U.S. Army War College. Her scholarship sits at the intersection of constitutional law, national security and homeland security law, and civil military relations. Her current projects explore flaws in the structural provisions of the U.S. Constitution relating to the exercise of national security powers and propose alternatives to the conventional checking and oversight mechanisms. But two little details about the professor that you may not know is, I think everybody who knows me knows that I am a huge Philadelphia Eagles fan. Well, picture that, except replace Eagles with Phillies, and you have my twin in spirit. And also, the second little known fact is that when I first moved to Harrisburg many years ago, although there was a 2 in the first number, it wasn't the 20th century. Professor Gaudion is actually the first person I ever met who lived in Harrisburg. So we go way back. Anyway, welcome, and I think, Noah, you're going to start us off, right?
Hello, everybody. It's nice to get the applause first. Excellent. So, hello, everybody. It is wonderful to be back. I want to thank the Widener Commonwealth Law Review for having me here, for inviting me to speak. And I'm really excited to talk to you about this project, which is something I was telling Professor's family and Gaudion. Something that I have been working on for some time. I've started it about 3 different times. I think there is something there. And so I'm delighted to have a chance to talk with you all about it and really look forward to your questions and comments at the end. Like the slide says, I'm going to be talking about the intersection of domestic intelligence and the First Amendment. And my thesis, please say my thesis is relatively straightforward. This one is it's multi-part. But it's that DHS and the FBI, in defining domestic terrorism, have what appears to me to be a misstatement of the law. And this misstatement, I argue, has 2 consequences. The first is that it obscures fundamental issues about government speech monitoring that are quite important. But if we're focused on sort of this erroneous understanding of the First Amendment, we can't get to those kind of key issues. This also highlights the broader challenge of taking First Amendment doctrine that was developed in an analog world and applying it to online speech. as we'll see going through it, right? So that is kind of the thrust of my argument, right? How are we going to get there? I'm going to start off by giving a little bit of background about domestic intelligence, right? What it is that I am talking about. I'm going to talk about this problem in the definition of domestic terrorism, and why that raises First Amendment concerns. And then I will get into what the consequences are of this inaccuracy. Before I do that, as Professor Family mentioned, I did used to work for DHS. I was an intelligence lawyer. I advised on domestic intelligence issues. I want to make very clear, I'm speaking here as an academic. I am talking about things that are all public record, right? So nothing here should be taken to reflect the legal position of DHS. In fact, as you'll see, I take issue with some things that DHS has done, right? I'm not DHS. So starting off with some background on domestic intelligence. Typically, when people think about the U.S. intelligence community, right, they think of the CIA, right, spies going off to foreign countries and trying to acquire information. Sometimes they might think of the NSA, right, signals intelligence, but we tend to think of the intelligence agencies as doing external-facing work, right, and that is a large portion of what they're doing. But we also have domestic-facing intelligence agencies. The reasons for this are straightforward, right? National security concerns don't stop at the border. They can also crop up inside the United States. And so we have agencies that look internally to try and identify those issues, combat them, right? And prevent them from manifesting, right? And so one of these problems that domestic-facing intelligence agencies, such as the Department of Homeland Security Office of Intelligence and Analysis and the FBI, work on is domestic terrorism. Okay? And this is a really, really difficult job, in large part because what separates terrorism from ordinary criminal activity is that it's politically motivated. Right? The goal is to try and intimidate or coerce the government into changing its policies or to impact the behavior of the civilian population, right? It's politically inflected. And that means that there's an intersection between what terrorists do and ordinary political movements, right? And the activities of political movements are protected by the First Amendment, acts of terrorism or not, right? This problem is compounded when you talk about online speech, right? And that's the kind of focus of our panel today, right? Is dissent online, and it's particularly difficult if you are a domestic-facing intelligence agency, right? Trying to identify potential terrorist actors. To do that online, it's essential to do because terrorists interact with one another on sites such as Telegram, right? But online speech and online communities, they have their own logic, right? They have their own language. Often, the kind of behavior that is acceptable online would be entirely antisocial if it happened in person, right? But these communities, right, just look different, right? And so we have these kind of two issues, the overlap between kind of people who might become terrorists and protected political activity and the difficulty with online speech. That brings us to this question about the definition of domestic terrorism that DHS and the FBI use. I'll put it up here on the screen, and I have clipped this, as you can see. Right? This is a screenshot from an intelligence report that was publicly released. And we're focused on the very last line of this definition, right, which says the mere advocacy of political or social positions, political activism, use of strong rhetoric, or generalized philosophic embrace of violent tactics may not constitute extremism and may be constitutionally protected. Now, the may not constitute extremism, that's a factual question, right? That's best left to the intelligence analyst, right? But the may be constitutionally protected, the last four words of that First Amendment caveat in the DT definition, right? That's a legal assertion. And I'm going to argue that it's flawed. And this matters, right, in part because this is a screenshot from one intelligence document. But this same caveat crops up an awful lot, right? And these are the ones that I could fit on the slide. There are more. And so this is something, right, that DHS and the FBI are saying frequently, right? This is part of their standard definition of domestic terrorism. This isn't a one-off thing, right? And the reason why this is odd is that those of you who have taken a First Amendment class or are familiar with First Amendment law, right, will know that dissenting political speech, right, is at the core of the First Amendment's protection, right? When we're talking about political expression, that's one of the key things that the First Amendment does is safeguard political expression, right? And there are a number of reasons for this. One of the most important ones is that the First Amendment is crucial to democratic self-governance, right? The idea being that we aren't truly free to elect people that we want to govern ourselves if we can't advocate for our own political positions, right? And so this doesn't mean that all political speech is protected at all times, right? There are certain categories of speech that fall outside of the First Amendment's protections, and that's true even where they're politically inflected, right? And so I want to talk about three of those categories today, and those are incitement, true threats, and fighting words. Right? Starting with incitement. The Supreme Court has said that the First Amendment protects advocacy of the use of force or of law violation, right? And this comes from a case called Brandenburg versus Ohio, which had to do with a speech given by a KKK member to other KKK members in front of a burning cross, right? Why we have that up on the screen. And what the Supreme Court said in that case is that, right, this advocacy of the use of force, right, or of law violation is protected unless it's directed at inciting or producing imminent lawless action, and it is actually likely to incite or produce that action, right? So the mere abstract teaching of the necessity of violence is protected. The reason why this speech is protected is that strong language, right, is thought to sometimes be necessary to convey a political point, right? That sometimes saying things that are shocking is important to conveying, right, the gravity of one's beliefs, right? And so what we end up with is a highly fact-dependent contextual inquiry, right, that looks into both, right, the speaker's intent to the extent that that's knowable, and the context in which that individual spoke, right? And the point here is that mere speech on its own, right, even where shocking, even where calling for violence in the abstract, the speech on its own isn't enough to make something incitement, right, to remove it from the First Amendment's protection. We see something similar in the context of true threats, right? This is another category of unprotected speech, and true threats are statements where the speaker conveys to their target or gives the person they're speaking to, right, a fear that they are going to be kind of subject to death or bodily harm, right? And the government must show, right, that the speaker disregarded a substantial risk, that's how their speech would be taken, right? It's basically a recklessness standard, right? Under this standard, political hyperbole, jokes, and vague statements are excluded, right? They don't count as true threats, right? And again, context is highly relevant. There's a case from the Supreme Court involving someone who is during the Vietnam War era. He said if he got his draft papers, the first person in the sights of his rifle would be LBJ. Right? He was prosecuted for that, for making a threat against the president. And the Supreme Court said that what he had said was protected speech because of the context in which he spoke it. Right? He was talking to other protesters. Right? He wasn't in a circumstance in which he was legitimately threatening the president. He was using political rhetoric. Right? And so here again, circumstances matter, and we need something more than the speech alone. Right? We also have potentially applicable the fighting words doctrine. This comes from a case called Chemerinsky versus New Hampshire. Involved a Jehovah's Witness who was preaching on the street. A mob came after him, and rather than protect him from the mob, the police took him away. Right? And so he yelled at an officer that he was, and pardon my language, he was a goddamn racketeer and a damned fascist. Right? And he was prosecuted for violating a statute that criminalized intentionally offensive speech. Right? And this case made it up to the Supreme Court, which said that he could be prosecuted under this statute because there are some words that people say, right, that are so noxious that they invite an immediate breach of the peace. Right? You say some things to someone, and you're gonna get punched. Right? So these are fighting words the court says are unprotected. The court has severely undercut the fighting words doctrine. It appears to be largely a dead letter, but it's still being enforced in some lower courts. They're still being applied in some lower courts. Right? But again, here context matters, right? You need more than the words themselves. And so my argument is that DHS and the FBI in this definition, right, are misstating the standard, and the definition properly should say, right, that it's kind of mere speech is constitutionally protected. Now, why does this matter, right? So my father is in the audience today, and he is fond of telling me, ever since I went to law school, that I'm splitting hairs, right? That I'm talking about these distinctions without a real difference, right? And so why does it matter, right, if it should say is and instead says may be in this definition, right? And my position is that there are three reasons. One is, right, that this definition has implications for how the government monitors speech. It also obscures more meaningful issues with government speech monitoring that are important for us to consider. And then finally, this highlights some of the challenges of applying this First Amendment doctrine, right, to online speech. So on the point about monitoring speech, this cuts both ways. Is that the FBI and DHS are authoritative sources, particularly for state and local law enforcement, right, who are on kind of the front lines of combating domestic terrorism, right? And so if the FBI and DHS are questioning, right, whether certain forms of speech are constitutionally protected, that might have kind of downstream consequences, right, where a state trooper, a sheriff's deputy, right, or a police officer is going to take them at their word, right, and have this erroneous understanding of what's protected speech and what isn't, and that could have downstream consequences, right? Conversely, uncertainty about what speech is protected could lead to governments under-monitoring speech or not taking action, right? There's a prominent example involving DHS, where DHS was aware that there were some people who were going to attend the protests on January 6th who were interested in breaching the Capitol, right, who had planned a riot beforehand. They had seen, for example, people passing around maps of the Capitol complex, right, and pointing out weak points and places where people could get in, right? And they didn't report on what they were seeing online, right, on these people who were planning to breach the Capitol. in part because they were concerned that what they were seeing was protected speech, right? Now, as it transpires, it doesn't matter if it's protected speech or not, right? If they've identified a legitimate security risk, they can report on it, right? But these kind of questions about what's protected and what isn't matter to the people who are doing speech monitoring, right? Also am concerned, right, that having this erroneous statement of the law obscures the real issues, right? That if we're focused on what's protected and what isn't, right, we're not focused on more meaningful questions, right, such as whether government speech monitoring is effective, right? And that should be kind of the real concern here, right, is not, well, is this unprotected speech and so it's fine, right? There are empirical questions that need to be answered about whether the government has a sufficiently compelling interest, right, in monitoring speech. And that's going to turn in part on how good are they, right, at identifying potential terrorist actors when they're monitoring what people are saying on social media, right? And so focusing on protected or not, including that in the definition, I think raises these concerns. Lastly, I want to talk a little bit about the kind of broader doctrinal implications. So I am not the first person to observe, right, that we have these speech doctrines that were developed in an analog world before we had the internet, before online speech took on such prominence in many people's daily lives, right? And there are a number of scholars who have identified ways in which, for example, the true threats doctrine doesn't work particularly well when you shift to online speech. And the reason for this is much of the context that courts care about, right, in determining whether speech is protected or not, has to do with the reactions of listeners and has to do with interactions that people have in the real world, not in cyberspace, right? And so it's difficult, as scholars have noted, right, for judges and lawyers to apply these doctrines. I just want to note, right, that these doctrines that we've been talking about, incitement, true threats, fighting words, are designed to be relatively straightforward to apply, right? They're fairly common sense, and they're things that, for example, police officers could apply while out in the field, right? But when we kind of strip much of the context that people would use, right, in figuring out whether something can be treated as incitement or not, becomes all that much more difficult to apply, not just for judges and lawyers, but also for people like domestic-facing intelligence analysts, for law enforcement officers, right? And that has kind of profound implications for how those folks are doing their jobs. So, a fair amount more I wish I could say on that, but I want to be respectful of the time. So thank you all, and I look forward to your questions after Professor Gaudion's presentation. Excellent.
Oh boy, Noah has set the bar very high, and I am notoriously not good at staying on time, so. All right, well, hello everyone, good morning. My name is Amy Gaudion. I have known Professor Flannery for a little while now. I am a huge Phillies fan. I'm also right now a huge UVA basketball fan, so I'm very excited about that. Did not wear orange today. Made my constitutional law students suffer through a really obnoxious orange outfit yesterday, though, to show my support. But let me echo the thanks to Kiera, to the entire editorial team at the Law Review. I have been in your roles, and I know how hard it is to herd all of us together. And so I really appreciate the timeliness and importance of this topic, but also all the background and logistical work here as well. And again, it's wonderful to be here with Dean Cummings, with the faculty at Widener. I think of this as one of our neighborhood institutions. Another of those neighborhood institutions that I'll talk a bit about is the U.S. Army War College. a little later in my presentation. Just as we're thinking about those of us in the educational space in central Pennsylvania. So let me say I'm going to try and read my notes. That is not my usual course of action, but I think this will help in two ways. It'll hopefully help me stay on time, right? But also I tend to wander. So Professor Flannery and Professor Chauvin are ready to block me if I start to wander off screen or anything like that. So I'm going to do this so I stay here and am faithful to our attendees over Zoom, as well as all of you in this room. Okay, so when I received the invitation to join this terrific program, I think Kiera described the goal of the symposium as fostering, quote, a First Amendment dialogue that traces the historical through lines of the original ideas of the Declaration of Independence amid the evolution of dissent in modern society. And they hope to put together a symposium that would highlight the delicate, discretionary balance of how First Amendment guarantees have shaped individuals' abilities to express their grievances amid turbulent political movements and climates. My remarks today are going to pick that thread up in a slightly less obvious space. Actually, in a space where expressing dissent is a lot more difficult, right? And where there are consequences, sometimes significant ones, for the expression of dissent. I'm going to focus on a particular category of individuals, active duty service members in the U.S. Armed Forces, and on the types of grievances that they bring, right? Challenges to U.S. Defense Department policy, challenges to use of force decisions. And my hope today is to do three things in this. First, give you a sense of what dissent looks like in the U.S. military. Does it look like this individual? You have a different image. Second, to identify and describe a trend of increasing constraints and limits on the ability of service members to dissent. And third, to demonstrate why preserving the channels of dissent for active duty service members is so critical in our constitutional scheme. And so my plan, the agenda, is to do so in the following ways. First, we're going to start with stories, right? Profiling several stories of dissent in the U.S. military from the founding to today. And as you listen to these stories, I want you to do several things. I want you to think about who is dissenting. Who's dissenting? Service member, right, on active duty, or a veteran. My focus is going to be on service members because veterans actually have similar First Amendment protections to those of us in a citizen or non-military status. I want you to think about, are they an officer, a non-commissioned officer, an NCO, or an enlisted service member? Which branches or services are they coming from? Do those in the Army or the Marines seem more likely to dissent than the Navy? Are there any gender or racial differences that you notice in who's dissenting? In addition, I want you to listen to what they are dissenting about. What's their message? Are they dissenting a specific military order, military strategy, specific military engagement, or a policy, right? Don't ask, don't tell, vaccination requirements. Or are they dissenting about a larger social justice issue? Okay, so you're going to look at who, what, and then you're going to think about how. What's the channel? What's the manner? What's the medium through which they're expressing their dissent? Are they raising that issue within the chain of command? Are they using a whistleblower channel of some sort? Are they attending a protest, writing an article, posting on social media? Right, pick your platform. Are they disobeying an order? They decide to resign. So again, you're going to look for who, what, and how in those stories. And in that how, that's where we'll be thinking about those channels, right? What are the channels available for dissent? And then third, right, we'll turn our attention to these constraints and limits, right? Why do we have some constraints and limits? Why do we think maybe our service members, right, shouldn't have the same First Amendment protections as those not serving, right? What are the benefits of allowing protest and dissent? And also, what's the potential harm? Harm to good order, discipline, obedience within chain of command. unit cohesion. So we're going to think through all those things, and in doing so, right, we'll be thinking about what's the line? How do we demarcate between allowable, desirable dissent and disloyalty, something that's harmful? Okay, so let's turn to these stories. And the first story is actually this photo. Does anyone recognize this photo? Okay, right, this is from a few weeks ago. This is Brian McGinnis, who's actually a veteran who served in the U.S. Marine Corps from 2000 to 2004. He's also a Green Party candidate for the U.S. Senate, right, in North Carolina, I believe. On March 4th, 2006, he attended a Senate Armed Services Subcommittee hearing, wearing his full dress uniform, and that's important, right? Interrupts the hearing, shouting, "No one wants to fight for Israel," and other comments opposing U.S. involvement. No, and other comments, right, opposing the U.S. involvement, right? So what he's protesting, right, is U.S. involvement in the war with Iran. He's removed, right, from the hearing room by Capitol Police and others, right? He's arrested on charges including assault of a police officer. Why did I use this photo? Why did I pick this photo? Right? It's certainly probably evocative in some ways, but I think it helps us think about these three categories. First, this is a veteran, right? Who's protesting here? A veteran, right? Not an active duty service member, so he's not subject to those same rules and constraints that we're going to talk about today. And he's no longer subject to the UCMJ. Second, it's helpful to think about the message, right? The message here, again, right, was a criticism of a decision to use force, a political decision. Third, what channel did he use? What channel did he use? He used a more traditional form of protest. He came in person to a hearing. He shouted. Finally, I use this photo because I think it really has us start to think about what does dissent look like? What's the image of dissent in a democracy? Does this photo align with your image of dissent in a democracy? Right? An individual in uniform shouting at a congressional hearing? Maybe it makes you a little uncomfortable. How's this different from an individual holding a sign at a protest? What I want us to do is maybe channel some of that discomfort, right, to help us think through the boundaries between dissent and loyalty. And writing actually back in 2021 in War on the Rocks, a blog that a lot of people in the military tend to read, Michelle McCander described the difficulty of this boundary drawing exercise. She said, dissent in the armed forces grabs headlines. From an active duty Marine Corps major arrested following his participation in the January 6th attack on the US Capitol, to an Army lieutenant colonel using his resignation letter to condemn his commander-in-chief. Unacceptable dissent is thriving. She goes on to say, the military's public repudiation of such dissent belies the truth that actively serving military professionals can and do regularly voice criticism in an acceptable, allowable manner. How dissent is manifested is key to understanding what separates the healthy and allowable dissent required for dynamic armed services from that dissent that is corrosive and unacceptable. That's what we're going to think through today. Okay, so first photo, right? First story. A few pages. Okay, this story actually predates the Declaration of Independence, right? As General George Washington began to gather troops for the Continental Army in 1774, 1775, right? He supported a policy that was going to exclude Black men, especially enslaved Black men, from serving. Now, this stance reflected both racial prejudice, right? Thinking that the Black soldiers would not be as capable, and also fear, particularly among Virginia landowners, that arming Black soldiers would encourage slave uprisings. So General Washington, right, thought there should not be any Black soldiers in the Continental Army. Well, several prominent figures disagree with him. John Adams, of course, was one of the most vocal. You've probably heard about that, but he's a political figure, right? He's not a military leader. But in addition, several military leaders expressed disagreement, and they challenged General Washington's decision to ban this enlistment, including most notably Nathaniel Greene, who argued for the enlistment of Black soldiers as a matter of military necessity, right, from a personnel standpoint, and as a stance that was consistent with the revolutionary cause. Henry Knox did as well. The result, General Washington rethinks, right, reconsiders the decision. He reversed course, he permits the reenlistment of free Black men, and in some cases, the enlistment of enslaved men with their owners' consent. And records indicate that 5,000 to 8,000 Black soldiers, both free and enslaved, served in the Continental Army during the Revolutionary War. Now let's be clear, the reconsideration of this decision by General Washington was not because he fully, was like, okay, I was wrong, right, in my initial decision. It intersected with manpower shortages and, of course, Lord Dunmore's proclamation, right, in 1775 of the British recruiting enslaved persons to join the British forces. But while it's certainly not the most noble of examples, this case, at the outset of the establishment of the Continental Army, created a space for dissent in the military forces. And it set foundations for this tradition of permitting dissent. Next story. This photo, right, was taken in April of 1945 at Freeman Field in Indiana. It shows 101 African-American officers, right, part of the Tuskegee Airmen of the 477th Bombardment Group. They had been arrested, right, and they were in line. They were about to be transported to Kentucky to a detention center there. This image was likely taken with a hidden camera by Master Sergeant Harold Ballou. Other photographs of the event taken by others were destroyed by white officers on the spot. So this is the remaining photo that we have. So why do we have this photo? Why do we have this photo? Well, the Tuskegee Airmen of the 477th, they protested discrimination on the base by trying to enter a white officers club in April of 1945, resulting in their arrest. Eventually, we have a court-martial. We have instances, right, of 101 possible court-martials. But after significant debate within the chain of command, right, they release almost all of the arrested officers. They try 3 of them, right, accused of physical alterations with white officers during the attempt to enter the White Officers Club and desegregate it. But the result is, President Truman hears about this. And of course, he's already starting to think about desegregation, but this is one instance of dissent, right, that contributes ultimately to Executive Order 998, banning segregation in the armed forces in 1948. So it took 3 more years. That's the story of dissent. This is Dr. Howard Levy. Pictured here, he's an Army captain. He was stationed at a U.S. Army hospital in South Carolina, Fort Jackson, I believe. Picture is from 1967. While on active duty and while treating service members, he vocally opposed the country's involvement in Vietnam. Indeed, he encouraged his fellow soldiers to protest alongside him by refusing to go. He told enlisted soldiers that he would refuse to go to Vietnam if ordered. He also claimed that special forces personnel are liars and thieves and killers of peasants and murderers of women and children. Right? He's court-martialed for those statements, right, under Articles 90, 133, and 134 of the Uniform Code of Military Justice. Again, this photo is him leaving his court-martial hearing. He is sentenced to 3 years in prison for violating those provisions of the UCMJ. He appeals it within the military systems. The conviction's upheld. He then appeals to the Supreme Court. Right? One of the most famous cases that we talk about in this case, Parker v. Levy. He argued that the articles, right, were vague and overbroad. They violated the First Amendment. The court denied that articulation. Instead, the court held that the military, right, can be subject to heightened regulation of speech. And that's because the military, right, is by necessity, the court said, a specialized society separate from civilian society. It also went on to say, therefore, this different character of the military means that the First Amendment should be applied more narrowly in that setting. So we have a general idea the military may restrict speech more than civilian society, right, because of these concerns about unit cohesion and military effectiveness. This is Marine Captain Zoe Bedell, right? She served in Afghanistan as the officer in charge of female engagement training units. In November of 2012, Captain Bedell joined 3 other plaintiffs in filing a complaint against then Secretary of Defense Leon Panetta, challenging the Defense Department policy excluding service women from ground combat positions. Right? The lawsuit said, based on outdated stereotypes of women, ignored the realities of the modern military and battlefield conditions under which women were already fighting and dying in active combat, and barred women's advancement to senior military roles. So again, that was 2012. In January of 2013, less than 2 months after the complaint was filed, the Department of Defense announced it was rescinding, right, the directive and starting to study, right, the policy that barred women from being assigned. And by 2015, 3 years later, Secretary of Defense Ash Carter issues an order opening all military occupations to women. Another lawsuit. This is Nathan Smith. He's 28 years old, right? He's a U.S. Army captain. He was deployed in Kuwait, right, in 2016. He'd been commissioned at that point in 2010. He'd been deployed to Afghanistan for 8 months in 2012, right? And he's in Kuwait. And he's there to fight the Islamic State. And he writes in the complaint, quote, "I consider ISIS an army of butchers, and I believe that participating in the fight against them is what I'm signed up to be a part of when I joined the military. But I'm conflicted." He says, "I'm conflicted because I believe this mission, the mission against ISIS, lacks a constitutional grounding." So he sought a declaration that President Obama's war against ISIS was illegal because Congress had not authorized it. Now, the suit is ultimately dismissed based on standing and political question ground. It's actually, for those of you who are in constitutional law right now, it's a great summary of those 2 doctrines. But the conflict continued, and Captain Smith continued to serve. All right, then we've got some social media ones. Anyone heard of Stuart Scheller? Okay. So this is a Facebook post that Stuart Scheller, Marine Corps Lieutenant Colonel, posted in August of 2021. Again, note he's in uniform. And in this post, he criticizes senior military and civilian leaders for incompetence in their management of the military withdrawal from Afghanistan. He calls out by name, right, in the video, Defense Secretary Lloyd Austin, Chairman of the Joint Chiefs of Staff, Mark Milley, and others for not raising their hands and accepting accountability for saying we messed this up. A few days after the video post, he's relieved of his command. He receives a letter of reprimand and is separated with a general discharge. Now, in 2025, Scheller is actually appointed by Secretary Hegseth to the Department of Defense, and he's currently serving as a senior advisor to the Undersecretary of War for Personnel and Readiness. Okay, last one. This is Mark Donahue. And again, if you go back to March of 2021, you may remember during Tucker Carlson's primetime cable TV show, he criticized President Biden for making the military, quote, more feminine. He went on to say, while China's military becomes more masculine as it assembled the world's largest navy, our military needs to become, as Joe Biden says, more feminine. So we've got new hairstyle and maternity flight suits. Pregnant women are going to fight our wars. It's a mockery of the US military. Mr. Carlson's segment triggered public backlash, right, from many, right, including Patrick Donahue, who posted, right, a video of him conducting a reenlistment ceremony in which he says, right, just a reminder that at Tucker Carlson couldn't be more wrong. The post went viral, right, got a lot of feedback, including from the Army, right, who investigated the post, right, conducting an investigation that ultimately led to the delay of Donahue's retirement, right, and a reassignment. And ultimately, the report concluded that Donahue's comments in response to Carlson, quote, while potentially admirable in their defense of female service members, nonetheless, quote, brought a measurable amount of negative publicity to the Army. Okay. So those are the stories, right? Those are the stories. And hopefully in those stories, right, you start thinking about who's bringing it, what they're bringing, and how. I'll just put up here some of the channels, and then we can maybe talk about this in the Q&A. Right? These are some of the channels for bringing dissent. Right? First one, you're supposed to go through the chain of the command if you can. Right? You're supposed to resolve it through the chain of command. But if not, you can bring in Article 138, right, or others. You can go to the Inspector Generals, you can go to Congress, you can work through the educational institutions within the military. Indeed, that's a really powerful space for dissent. You can also use social media. You can also use lawsuits for all the channels that we have. And of course, right, at the very end, disobey an order. I highly recommend Dan Mauer's scholarship in this space, right? The difference between a lawful and an unlawful order and the ability to disobey, or you could resign. I'll talk just for a moment, right, about resignation. This is the last resort channel, right? And it's a controversial one. All right, so we've got the channels. Let's talk about some of the constraints, why we might need to constrain, right, the ability of active duty service members to dissent, even though we think it's valuable, right, in so many ways to that civilian control of the military. Why are constraints existing? Well, we've got three kind of basic sources of constraints. I won't talk much about them, but just so we're aware of them. But the idea, again, right, is that because of that special society, right, that they talked about in the Levy case, because of that special society, we need to have heightened constraints on the way that active duty service members dissent. And so we're going to put these constraints in the Uniform Code of Military Justice. You could be subject to a court-martial or other non-judicial punishment. And we're going to give you lots of guidance, right? These are the department level guidance on how to use social media, what extremism means. And again, I'd love to talk to Noah about, this definition I think is really different than we're seeing in the civilian side with DHS, right? But also you'd have constraints at the service level, right? The Army has slightly different constraints than the Navy, and then at the command level. But I want to wrap by talking about why the trend towards increasing those constraints and limiting the channels is concerning. So I'll highlight just a few. I told you could seek dissent through the Inspector General. Well, President Trump fired a number of Inspector Generals. Secretary Hegseth has refused to comply with Inspector General requests. And then there's been a push to tighten IG investigation timelines and limit access to Inspector Generals by service members. You've probably been watching, right? We've had a number of constraints in the education context, both through President Trump's executive order, as well as some limits from Secretary Hegseth on the types of schools that active duty service members and senior officers can go to, right? No longer Harvard, right? Starting in the 2026-27 academic year, discontinuing all graduate level programs at Harvard, as well as 22 other elite colleges, universities, and institutions, because accordingly they are too woke, right, and have bias and are not sufficiently aligned with American values. I'll just hit this last one and then I'll wrap up. I think this is really important. Has anyone ever heard of Stars and Stripes? Okay, right? This is a publication. It's been the flagship source of news and reporting since World War II. Its employees are U.S. Army civilians so that they're not subject to the chain of command and good order and discipline, right? It's known for its editorial independence, protected by Congress, specifically to prevent political leaders from feeding troops propaganda. Well, earlier this year in January, Sean Parnell, the Department of Defense's chief Pentagon spokesperson, announced that the administration was demanding changes to Stars and Stripes that would, quote, modernize its operations and, quote, refocus its content away from woke distractions that siphon morale. And just yesterday, March 19th, the Pentagon's own publication, Stars and Stripes, was disinvited from Defense Secretary Pete Hegseth's latest Iran war press briefing. We weren't allowed to go. So again, we've got this kind of trend of constraint and of limiting channels that I think we should be worried about. And I think we should be worried about that, right? Because we've got some significant challenges ahead. When I'd like to hear some dissent from our service members, right? I'd like them to engage, even if that's just within the chain of command and elsewhere. Right? They have that special perch, that perspective on issues that we may not as members of the public. And so there's value in that dissent. We want to make sure that we preserve it. All right, I will wrap up there and take questions. Thanks, everyone.
Thank you so much for those both excellent presentations. We have about 10 minutes or so for questions. So who in the audience has a question? We have some students who have microphones that they'll give to you. We had a question in the back.
This question is for Professor Chauvin. I wrote it down so I wouldn't forget. But the determination of protected speech is necessarily fact-dependent, but also seems largely subjective. How does that uncertainty affect the government's ability to then classify groups as domestic terrorists? And then does that classification then justify further restrictions on what would otherwise also be protected free speech?
Question. I'm not sure if the microphone. Oh, there we go. So it's a good question. And so I'll say, right, it's not supposed to be subjective. These are supposed to be kind of objective tests, right, based on sort of observable facts and circumstances. I think there is a fair amount of flexibility, right, that's built in there, and because it's so context dependent, right. On the question of sort of designating domestic terrorist groups, so interestingly, and we're seeing kind of shifts in this at sort of the executive directive level, right? But there is no kind of formal statutory mechanism for designating domestic terrorist groups, right? So departments and agencies such as DHS and the FBI are authorized to combat domestic terrorism, right? But they focus on the action, and it's not like you right, if you join Al-Qaeda, right, you've joined a designated foreign terrorist organization, right, like by virtue of being a member, right, you're a terrorist. We don't have statutorily, right, a kind of similar mechanism for domestic terror. President Trump has designated Antifa as a domestic terrorist organization. It's a little bit unclear exactly what that means. And so there's a case playing out in Texas right now involving an attack on the Prairie Land Immigration Detention Center. There was a protest there. Protesters brought a rifle and attacked some police officers, shot them, and is being prosecuted for that and for providing material support to terrorism, right? And so the kind of answer on like how that flexibility, right, interacts with referring to something as terrorism is it's a little bit unclear, right, in that we don't have these kind of formal designation mechanisms, so a lot of it's going to happen on a very case-by-case basis, looking at a particular individual's kind of actions and motivations and trying to determine, right, whether they're politically motivated or not.
Thank you. That was great presentations by both of you. I'll have a question for each of you. So starting with Professor Chauvin. You know, the whole game here, it seems like, is on the one hand, you know, asking the question is, when is speech so dangerous we have to do something about it? It's got to be able to suppress it. On the other hand, we're committed to robust dissent, to be able to criticize the government, to, from the top of the mountains and yell it out. And, if you tip too far in terms of what's dangerous, then you end up China saying in the name of national security, taking away all free speech in Hong Kong. But if you tip too far in favor of speech, there's a lot of dangerous speech that's not likely to lead to imminent harm or anything. Instructions on how to make anthrax, glorifying, publicly glorifying a terrorist act like 9/11 after it occurs could encourage similar kinds of things. Just in the paper yesterday, there was an article about how online people get together who end up being school shooters, and they're sharing maps of schools and talking about how depressed they are and how to get attention. So for you, I'm wondering, you mentioned some of the relevant doctrines. Do you have ideas of, where there may need to be tweaks in the doctrine to kind of figure out where that line should be? And sort of in the same for Professor Gaudion, the same kind of line drawing, it seems like there's two kind of boxes. One kind of box could be speech protesting a lot of your examples were just discrimination within the armed forces. It didn't seem like the kind of thing that undermines the mission. It's just, this is unjust. But the other box could be speech that arguably threatens the chain of command or undermines the mission. So can soldiers in uniform say things like, we are allowed to disobey illegal orders, but who gets to define what's illegal? Can they say things like, this war is a mistake, we are killing, well, it's like the Levy case, we are killing innocent people, day after day with no progress. So, on that box, is it, how do you regulate that box?
So it's a great question, and I'm not convinced that we need sort of tweaks to the doctrine to address the issue, right? And this is part of my concern with, I think this is inaccurate, but even including this First Amendment caveat in the definition of domestic terrorism, I think, like I said in the presentation, I think it obscures the real issue, right? Which is not whether this is protected speech or not. The government has entirely legitimate reasons why it might want to monitor even protected speech, right? If it gives an understanding of this is what is motivating, right, domestic terrorist actors, I think that's entirely legitimate for the government to do. I think it's consistent with strict scrutiny, provided that the agencies doing this monitoring can actually identify, right, what is going to lead to these acts of domestic terrorism and what isn't, right? And I think there are serious questions about that, but I'm not sure that the doctrine needs to be tweaked. I think this framing of kind of protected versus unprotected isn't really relevant to kind of the actual issues that these agencies need to confront.
So I'll address it in two ways. First, I think, what's that line? What is, sorry. How about now? Better? Okay. What's the line? And the Parker v. Levy case tries to draw it, and there have been subsequent cases. A lot of them actually are coming through the Court of Appeals for the Armed Forces, though, right? Because it's going to come through that channel as opposed to the civilian course. And so I think there's a limiting principle there that's working pretty well, which is to say you really have to have a pretty tight nexus that the expression in some way, right, has a harm to military functioning, whether that's good order and discipline. And there have been some interesting cases coming along there, really trying, I think, to make a narrower category of what would be prohibited. So if a service member is engaged off base, they're not wearing a uniform, right? Even if it's very critical, we're going to allow that speech to continue. And I think that's a good trend and probably a good, an appropriate line. I do think there's a embedded concern, though, about the judiciary, and that's the deference that all courts give to military decision making, right? So a lot of times courts won't even engage in the discussion or in the merits of it. So that's worrying to me, and we can talk more about what that might look like. But on the defense policy, I would encourage you all to go check out Department of Defense Instruction 1325.06. That's the one that governs extremist behavior in the U.S. military, right? This was revised significantly after January 6, 2001, when we learned that there were service members. Indeed, there are only 6 active duty, I think 3 serving in the Marines and 3 National Guard, but a number of veterans, right, involved in January 6 and subject to or actually convicted before the pardons. But that instruction, in its effort to be more comprehensive, really failed to address the gap. And Rachel Van Landingham has written a lot about this, but I think this example is the most illustrative. She says the revised instruction now allows passive participation in extremist organizations while prohibiting active participation in a certain set of expressly delimited extremist activities online, which leads to this inconsistency that a service member can be a member of the Ku Klux Klan, but cannot, they're prohibited from liking a link, right? Liking a social media post about the Ku Klux Klan. That doesn't seem to be working well. So I think we've got some work to do on that direction, that instruction within the Department of Defense.
Take one more quick question. If we have another question.
Professor Gaudion, I'm sorry.
Gaudion,
sorry.
Like you're cheering for Deion Sanders.
Gotcha.
Go Deion.
So I noticed that your examples of early, more successful dissent were both at times of more limited publication of information and also both during times of active warfare. And more recent ones were less successful or less impactful. And those are times where information is more publicly, basically instant dissemination of information, and also at a period of much more asymmetric warfare for the United States. So do you see the shift in both technology of warfare and communication resulting in essentially less meaningful dissent in the military, or is that just the examples that are available here?
Yeah, that's a great question. That's an excellent question. I think the trends really go to somewhat of what are the issues, right? What's the message or the what? And I think we are seeing military, particularly leaders, a lot of these are officers, less so enlisted in the examples that I gave, although there are certainly others, are really focused more on external issues to what's going on in the military. Sometimes it's about a particular engagement, but it's more about social justice issues, right? The vaccine requirements, while certainly about a military decision, were about a larger discussion. So I think that's one thing, and that's a pull that, at least in my view, is a good engagement, a good use, right, of dissent. But the larger trend that I see is really a shutting down of all of the internal channels and much more appropriate channels of dissent. So then everything is getting pushed to social media, which does not actually allow for an exchange to engage debate and discourse. And I think that's one of the real problems and challenges. And that's why I'd like to see, not so much constraints on what chain of command on educational institutions, discussion forums, right? But maybe a larger articulation of what the rules are governing social media.
One more round of applause for our panelists. Thank you all so much. I believe we have a short break and we'll be reconvening at 11.
All right, can we get back to our seats? this is actually so, for me, awe-inspiring, and actually I have to begin by just acknowledging that this is obviously the accelerated section, because we had a 15-minute break that actually turned out to be 15 minutes, right? Normally my experience with these things is that a 15-minute break is in the vicinity of 25. But you are all very eager, and no doubt the reason that you're all very eager is we had a wonderful first panel, and let me begin by just, if we could give them another round of applause for Professor Chauvin and Professor Gaudion. In addition to welcoming you all back to this year's Law Review Symposium after the break, I would also like to welcome our 3 distinguished panelists to the Widener Commonwealth campus. The first is actually no stranger to a lot of you, the Honorable Judge Karoline Mehalchick, right? Also, by video, Professor Chad Oldfather, and then Professor Wendy Scott at the end. For those of you who were curious, Professor Oldfather had planned to be here in person until he found out that I would be moderating the panel, and then he said he would prefer to do it virtually. One thing I guess I should also share with you is, as much respect as I have for the first panel and their presentations, I should share with you that when Kiera asked me to do this, to moderate this panel, I had a request. And that request was that I would only do it if I was allowed to moderate the most engaging and intriguing panel. And she said that that was a big ask, to which I responded, and I'm a very old person. And her response was, Professor Lee, that is actually true. I suppose I should acquiesce. That had not been my hope for her response. But then I remembered a statement that Professor Deem had once shared with me when I was on the brink of complaining about something. And he said, Randy, did you get everything you wanted? And I said, yes. And then he said, then be quiet. So, Kiera, as long as you gave me everything I wanted, the personal insult will only wound me deeply. With that in mind, I will be introducing each of our panelists as they begin. So let me begin by introducing Professor Chad Oldfather. I think somewhere in the internet, their full biographies are available. They told me to keep their introductions brief so they would have more time to talk. But I just get all excited when I meet new people. So I'm going to keep them as brief as I can. Professor Oldfather, Brian told me that we will not be able to see him. So for those of you who are wondering what he actually looks like, imagine a combination of Matt Damon and a young Robert Redford. Professor Chad Oldfather is a professor of law at Marquette University Law School, where he teaches constitutional law, criminal law, evidence, state constitutional law, judging and the judicial process, and seminars on constitutional theory and jurisprudence of sport. In 2016, Professor Oldfather was selected by student vote as the winner of the James D. Giardi Award for Teaching Excellence. Prior to teaching, Professor Oldfather was a lawyer in the Minneapolis office of Fager and Benson, and also served in the appellate office of the Minnesota State Public Defender's Office. Professor Oldfather regularly speaks to audiences of judges, lawyers, other scholars, and the general public about a multitude of interests. His recent book, Judges, Judging, and Judgment, Character, Wisdom, and Humility in a Polarized World, was published by Cambridge University Press. His work has also appeared in a wide array of law journals, including the Georgetown Law Review, the George Washington University Law Review, and the Vanderbilt Law Review. In recognition of his scholarly achievements, Professor Oldfather is a past recipient of the Howard B. Eisenberg Prize by the American Academy of Appellate Lawyers. He is also the author of A Man Walks into a Barn, Navigating Fatherhood in the Flawed and Fascinating World of Heroes, which the Wall Street Journal described as both witty and wistful. Professor Oldfather. I'm just going to go check on something. Once more, Brian anticipates my every need.
People on Zoom could hear him perfectly. All right, Chad, try that again.
All right, can you hear me now? Excellent. So this is all a little too reminiscent of the early days of COVID, unfortunately. So I guess as the people on Zoom heard, I wanted to be there. I tried to be there. I spent a lot of time yesterday on airplanes, and unfortunately only a very small fraction of that was actually in the air. So we're doing it this way instead. The topic of our panel, of course, and of my presentation is dissent in the courts. And dissent is obviously a longstanding, a common, and a valued component of the judicial process, including strongly worded and often heated dissents. But I do think there's a sense, at least among some of us, that there's something different maybe that's taking place with respect to dissent and the nature of judicial dialogue more generally. So this is a presentation, and I'm really sincerely here asking a question as much as I'm posing an answer. And unfortunately, I wish I could be there to discuss it with folks. But the question is, when might dissent within the judiciary cross the line of being productive and turn into what we might think about as delegitimization? When might it become counterproductive? And I think we're seeing that line crossed more frequently lately. I think that's connected to our polarized society. I think it's connected to polarization in our profession. I should note as a bit of a caveat that I'm going to be drawing on, and a lot of my views are formed by my perceptions of what's going on in the Wisconsin Supreme Court, which is, I hope, not representative of what's going on in courts more generally, although there is some sense that it is. And to support that, here's this first slide. This is just, a collection of headlines that that does seem to support the idea that there's something different going on, that the nature of judicial discourse is changing. That we now have judges who are edgelords, that we have snark, that we have inappropriate tones and so forth being taken. I want to zoom out and just think a little bit briefly about what is it that dissents do? What is it? Is it positive? Is it negative? There are, as is usually the case, two sides to this coin. For the most part, people tend to think about dissents in the judicial process as a positive thing. Right, majority opinions, you will probably have noticed fairly quickly during your journey into the law, tend almost uniformly to be written as if there's a single correct answer, right? The logic just sort of flows, even though we all understand that at least a lot of the time, legal questions are hard and the answer isn't so obvious. And so dissent kind of pushes against that a little bit, right? Dissent will involve a process that can be regarded as enhancing the deliberative process. Judges and justices have frequently remarked over the years that a majority opinion will get circulated among the members of a panel. There's a dissent, and then the author of the majority is forced to rethink things a little bit. And what tends to result, at least much of the time, is a stronger majority opinion, right? So it enhances this kind of collective deliberation that we want judges and courts to be engaged in. It can contribute to the development of the law, right? You've got a judge in dissent who says, look, I see the world a little bit differently. Either I think, majority, you got this question wrong, or I think the law here is wrong and we ought to be thinking down the road a little bit to whether we ought to change it. And it's a seed that gets planted, and the dissenter often hopes that a future iteration of the court, future lawyers, maybe the public more generally, will nurture that seed, and that the law will change as a result, right? And all of this can then be regarded as enhancing the legitimacy of the judicial process, because lawyers, litigants, law students, the public more generally, all of us can look at this and see that here we have judges who are engaged in a real good faith way with trying to get the answers right, which is, of course, exactly what we want. Of course, there's another side to that coin, right? Some people have tended, some judges, some commentators have tended to say, well, I don't know. I think having a dissent there weakens the force of the decision, that it tends to make it look like it might be a product of something other than the law, which in turn creates uncertainty about what the law is. Sometimes it can negatively affect the collegial relationships between judges on a court. And all of this, these folks say, maybe it tends to undermine the court's legitimacy. So that's the basic lay of the land, very quickly laid out. What about tone? What about the strength and the vigor with which these dissenting opinions are offered? Right, that slide of headlines that I showed suggests that maybe there's something new going on, that there's a level of aggressiveness that hasn't always been present. Well, I think it's easy to imagine the good old days as being better than they were. Sadly, I'm forced at this point to admit that 1983 is a long time ago. And in 1983, Judge Richard Posner observed that, look, terms like judicial activism, result-oriented judging, right? These terms of what he called judicial abuse, they're all over the place. That, it's worth noting, came in a year in which Antonin Scalia was still Judge Scalia. He wasn't yet Justice Scalia, right? So obviously that's a name we think of when we think of strongly worded dissents, but he wasn't. He had not made his name in that way as of the time that Judge Posner wrote. So it's not that there's never been, and in fact there probably always has been, a set of dissents that are fairly strongly worded and heated. But I do think maybe there is something slightly different that we're seeing now more often these days. And here I'm going to go with a recent case from the Wisconsin Supreme Court. It's a statutory interpretation case. It was handed down during the court's last term. And the specific question that the court was considering doesn't matter for our purposes. What I'm going to focus on is a debate in a couple of separate opinions between two of the justices on that court. Turns out they're both concurring opinions, but I don't think that undercuts the idea of dissent here, because in this first opinion, Justice Rebecca Dallett, who I think it would be fair to characterize as the leader of the court's liberal wing, she's calling into question the wisdom of an approach to statutory interpretation that the Wisconsin Supreme Court has adhered to for a good couple decades at this point. Sort of a modified textualist approach, which really often ends up boiling down to when, if ever, or debates over when, if ever, we should look at legislative history. And Justice Dallett's position is essentially to say, I agree we should start with the text. I just disagree with the idea that we should categorically relegate legislative history to some second or third class status. Sometimes it's actually good information, and we as judges should be able to account for that. Right, so she's advocating a more pluralist approach, and the key point for my purposes is she's not saying anything radical or new here, right? There's a long-standing debate within law over how to best go about interpreting statutes. She's just advocating for a switch to the other side of that debate relative to where the court has been, right? It's very much a position within the mainstream of American law. Well, that, as it turns out, is not how her colleague, Justice Rebecca Bradley, viewed Justice Dallett's approach. Right? She characterizes that approach as advocating, quote, an interpretive method embraced mostly by far-left progressive jurists. She says it would remove any remaining constraints on judicial overreach. It would unmoor the judiciary from the rule of law. She spends some time lamenting the fact that the majority of the court has flipped from conservative to liberal, and that this new liberal majority feels itself empowered to the point that Justice Dallett, quote, no longer feels constrained to keep the quiet part quiet, and that what they're going to do is dispense with the rule of law in favor of their own personal or political predilections. And if they go ahead with this change in interpretive methodology, the rule of law shall be consigned to burn in perdition's flames, which is pretty strong language. And the question is there something qualitatively different about this as contrasted with all of the sorts of dissents that we are familiar with? So to take a cut at thinking about why there might be, I think we can think about disagreement among members of a court as falling into three categories. And these are more, points on a spectrum rather than discrete categories. But I think they capture something. One of them is micro level, right? There might be disputes over the specific features of any given case, right? What's the inference that we should draw from fact X? What's the proper reading of this precedent that is the one that seems to guide our resolution of this case? How does this statutory language apply, et cetera, right? It's a disagreement that isn't going to spill over into or have great implications for any other cases. It's really a disagreement about how this one should come out. You can go up a level of generality and have disagreement over proper ways of using the tools of legal argument. Not disagreement about what those tools are, just how they should be used. Should we read past cases narrowly, or should we read them more broadly? How should we apply and prioritize canons of statutory construction? That sort of thing. And that, of course, does spill over potentially into other cases, but we're staying within the umbrella of moves in the game, so to speak, that everyone agrees are appropriate. And then there's kind of macro level disagreement over whether certain tools of legal analysis and argumentation are legitimate at all. And I think that's what's going on in this dispute between Justices Dallett and Bradley, where Bradley's saying, you're attempting to make moves that are categorically invalid. And I think there's something different about that. I think that what Judge Posner was referring to, I think that the strongly worded dissents by Justice Scalia that we all tend to think about, if you look at those, they're almost entirely, if not entirely, disputes or charges leveled at the micro or mid levels, right? When in Romer versus Evans, Scalia characterizes the majority's opinion as having no foundation in American constitutional law, or when Chief Justice Roberts, in his Obergefell dissent, says the Constitution had nothing to do with this. I think the thrust there is mostly, you got this case wrong, rather than your entire approach to doing law is wrong. Again, I think that's a matter of emphasis, but I do think there's something there. So how do we think about this? In the interest of time, I will not linger long on, or really at all, on the notion of a Wittgensteinian practice, and I'll simply suggest this, that I think it's fair to say that the rules of the game can and do shift over time, which does not mean that there are no rules. In other words, it would be entirely appropriate, were I a judge, and were I to decide in a hard case that, you know what, I can think of no better way to decide this because the arguments are balanced, I'm going to flip a coin. it would be entirely appropriate for one of my judicial colleagues to call me out for that. That's not a permitted move in the world of legal argumentation. That would be violating the rules of the game. That would be using an illegitimate tool. So it would be legitimate for me to be called out for that. I think it would be legitimate, likewise, for me to make the case, difficult though it might be to make, that, you know what, sometimes flipping a coin is perfectly acceptable. That if it's a hard case and we can think of no better way to do it, then why not go to something random? And if I could convince enough people, if I could convince all of you, if I could convince my colleagues on the court, if I could convince society more generally that flipping a coin sometimes is a legitimate move, then I think the law might shift to recognize that. What I think is problematic, and what I think might be going on in this Wisconsin opinion, is that it labels a non-violation as a violation, right? That when Justice Bradley levels those accusations at Justice Dallet and says, you're just casting the rule of law aside completely, that strikes me as being different from saying you're flipping a coin. Because all Dallet was doing was arguing in favor of a longstanding side in the debate over how do we implement the rule of law in the process of statutory interpretation. Right, so the question then just becomes, when does this disagreement, when does it become delegitimizing? When do statements made in dissent threaten not to further the rule of law, despite flying the flag of the rule of law, but instead to undermine it or to delegitimize things? Maybe it's a question of tone, right? Maybe if Justice Bradley's tone were more moderated, I might not find it as troubling. Conversely, maybe this is just me getting old, right? Maybe as social media conditioned generations come through, this sort of exchange will be regarded as perfectly normal, perfectly acceptable. Maybe, but on the other hand, the judges engaging in this behavior are all of them roughly my age, so I'm not sure it's about tone entirely. In a very recent article just published this year in the Iowa Law Review, Allie Larson and Neil Devins of William and Mary Law School say it's the audience, it's the intended audience that's the key, right? That it's perfectly fine if judges are they're writing for one another, and they're writing for the litigants, and they're writing for the profession, and they're attempting to shift the nature of the conversation. That's fine. What's problematic, they suggest, is when judges or justices are writing primarily for external audiences. They're writing to show allegiance to a particular side or cause. They are writing perhaps to attract the attention of someone who might appoint them to a higher court. That may be part of it. I think as well, and I'm not sure I'm convinced of this, but those who've been around since the 1990s may recall philosopher Harry Frankfurt's essay on bullshit, where he tried to draw a distinction between lying and bullshit, which is focused on the speaker's attitude toward the truth and their audience's perception of the truth. Right, with the liar intentionally engaged in an act to deceive, and the bullshitter not really caring, being indifferent to the truth value of things. And perhaps that's a way of characterizing this, because certainly I don't think a judge or justice asserting that a longstanding approach within American law is an illegitimate approach. I can't believe that they think they're deceiving people. But, you know, this is one of the questions I'm asking, and I'd be grateful for any input that folks have. So what am I worried about? Where does this all end up? My ultimate worry is this, right? If we have two camps, right? If we were to cleave into a world where some people say, you know what, textualism is the only legitimate way of doing statutory interpretation. Other people say a more functionalist approach is the only way to do statutory interpretation, and they regard one another as illegitimate, then we got a problem. Then we're in a situation analogous to what happens in worlds of sport or games where you have these competing established camps who can't agree on what it is they're trying to do. And so what ends up happening, you get two associations, two different versions of the same sport. They separate from one another. That's not a good thing when it comes to a legal system. Obviously, we're doing this conference in the shadow of the Declaration of Independence. The Declaration of Independence is perhaps a primary example of a situation where one group of people said, you know what, we disagree. We disagree collectively with the approach that we more broadly are taking. We're not going to stand for it. We're separating out. That worked out well. In that context, I'm not sure it would work so well in ours. So I do worry. And I'm still puzzling through. So I'm absolutely interested in people's reactions to when it becomes the case that language and accusations of the sort that we see in Justice Bradley's opinion, and I think elsewhere, when those threaten to undermine the rule of law rather than support it. And I apologize if I went a bit too long there, but I hope you'll forgive me. Thank you.
You seem very youthful to me, so don't worry about getting old. Our next speaker is the Honorable Karoline Mehalchick, who is a U.S. District Court judge for the Middle District of Pennsylvania and is also this year's jurist in residence here at Widener Commonwealth School of Law. Before her current appointment, Judge Mehalchick served for over a decade in our district as a United States Magistrate Judge, including time served as the Middle District's Chief Magistrate Judge. In addition to teaching here at Widener, Judge Mehalchick has also taught extensively as an adjunct at Marywood College. Judge Mehalchick began her legal career as a clerk for the Honorable Trish Corbett, the first woman judge of the Lackawanna County Court of Common Pleas. From there, Judge Mehalchick joined the law firm of Oliver, Price, and Rhodes in Clark Summit and ultimately became a partner there. In 2021, Chief Justice Roberts appointed Judge Mehalchick to the Judicial Conference Committee on Codes of Conduct, and she also currently serves as president of the National Federal Bar Association. Judge Mehalchick has received numerous honors, including PBA's Michael K. Smith Excellence in Service Award and PBA's designation of Judge Mehalchick as a woman trailblazer. Judge Mehalchick?
Thank you. So thank you for that, and thank you for having me here today, Kiera. Thank you for asking me on this. This is the topic of dissent as a trial judge is an interesting one to tackle and to think about, but really important. And I was thinking about the panel and thinking about how dissent plays into my work as a trial judge and to work as lawyers and in our profession in general. There were a couple quotes that came to mind, and I'm going to start with one and end with one. And the first is a quote from Aristotle, and he said, "It is the mark of an educated mind to be able to entertain a thought without accepting it." And that really, I think, encapsulates the importance of dissent, the importance of considering dissents and other people's perspectives. I think it's really an important aspect of the job I do on a daily basis when I'm listening to two or more sides of a different story. There's, I forget how I'm going to say it incorrectly, but the idea that, when you have a case come to court, there are not just two sides, there are probably 5 different sides of it, and the truth is somewhere in the middle of all of those. And so we think about that as a trial judge and how we might disagree with someone or how it's handled as lawyers. And so I'm going to focus on really three sort of aspects of dissent here: why it's important in our practice as lawyers and as trial judges, why it's important about how it's addressed. And you heard Professor Oldfather talk about that a little. I'm going to follow up on some of the things he said. And then what should dissent not be? And I think that's really, really an important spot to start and then go back to, because we are You know, I those of you who were 1Ls when I administered your oath of professionalism, you heard me talk about this. If any of you have been in my classes, you hear me talk about it a lot. But we live in a time where it is important to be able to speak your mind with and disagree with judges, and to do so in a manner that is following the process that our Constitution lays out. And not in a way that is violent or threatening. So I'll get back to that near the end of it. But I was thinking about where we are here on the year of the 250th anniversary of our country, this birth of this great experiment that is our country, and one that was really founded on the idea that we have different opinions than a king, and we have different opinions and we shouldn't be punished for those opinions if we disagree with our government. And so the founding generation comes here and they create this nation, and they start with the Articles of Confederation, right? And that doesn't go so well. And they form this Constitutional Convention. And I was thinking about the Constitutional Convention in terms of dissent, because you know that when the framers got together to have this convention, they spent May to September of that year in Philadelphia in a hot, muggy summer without air conditioning, and they're struggling to figure out, how do we create a stronger national government here, but one that also protects individual rights. We have a country built on the idea of freedom of consciences, this freedom of expression, the ability to speak without fear of retribution. And yet they didn't all agree. Anyone who has studied the Constitutional Convention at all knows that they had to figure out, how do we elect an executive? Is it one executive? Is it three executives? What do we do about Congress? Do we keep one house? Do we have two houses? What do we do about the judiciary? Do we have lower courts? Do we have inferior courts? Do we appoint them for life? How do we make an independent judiciary? Is it important to even have an independent judiciary? And so from the get-go, this country is founded on the idea of dissent, and the idea that people are going to disagree and do so in a manner that is going to eventually come together, but they're going to be open to other ideas. And we end up with a number of compromises that get into the Constitution. Some of them were, in the end, not going to last very long. But you have this idea that this country back then is focused on, we have different ideas, we have different perspectives. We should be open to those different ideas and different perspectives, but we need to address them in a professional manner and in a civil manner, and that it's okay to have civil discourse. It's okay to have disagreement, but we should be doing so in a respectful way, and one that values everyone's different opinions. So that's where we start. So now we have, the judiciary working through dissents. And I can tell you, practically speaking, where dissents come into my work, because trial judges, as you know, we don't have a panel. I don't have two colleagues writing or deciding a case with me, or nine, or there's not 9 of us making a decision on a case. It's just me. And I look at dissents in different ways. So sometimes they are useful, particularly when they're out of our circuit, to see how different courts may have handled an issue. Although it doesn't happen too frequently, it does happen sometimes that there are issues that come before the court that don't have any precedent in the Third Circuit. I sit in the Middle District, I sit in Scranton, Third Circuit's my Court of Appeals. Sometimes there's not an answer in our circuit, and so you might look to another circuit. Well, the Fifth Circuit, for example, is not binding on me, but there may be a dissent that I find interesting, slightly persuasive. So there are dissents in other courts that may be useful to a trial court making a decision. They are interesting because they show different perspectives. Sometimes things change. Dean Cummings mentioned Plessy, he mentioned Dred Scott. Those dissents in those cases were prescient, and they had an impact later in our country's history and in our jurisprudence, with how laying the groundwork for cases like Brown v. Board of Education. So those dissents are not always something that are gratuitous or extra. They are useful to trial court judges when they're wrestling with issues that aren't necessarily spelled out very clearly in our own precedent. Throughout history, throughout the work of trial judges, there are incredibly hard issues that we have to look at. And sometimes looking at those dissents changes a point of view. I think that the very nature of having disagreements and having disagreements in a civil manner is the idea of being able to entertain those other points and possibly being persuaded or possibly bolstering your own argument. When I talked to years and years ago, I coached high school mock trial students. And one of the things that we always tried to stress for them, the team of advisors, that's not a royal we, I'm not that person, but the team of advisors would say is, you better know your opponent's argument better than you know your own. Because if you know their point of view, if you understand what they're thinking, you're going to be stronger in your own argument. And I think that holds true for dissents. If you're looking at a dissenting opinion, then you may understand your own opinion better as a trial judge. If someone disagrees with you, you're going to be able to explain why your opinion is important and why you think it's better based in law and based in the facts of the case. One of the other really interesting spots that we see dissents as trial judges, and it's not technically a dissent, but within our district, and this happens in every district court, it's not unique to the Middle District of Pennsylvania, we get along fairly well, all things considered, is that I may disagree with one of my colleagues on the district court bench. Now, if Judge Mannion writes an opinion, he's a co-equal district judge. He has some years on me in terms of being senior to me on the bench, but he's a district judge like I'm a district judge. We have the same commission. He has written an opinion before, and again, in the absence of Third Circuit precedent, I've looked to that opinion. I find that it was interesting, but I didn't agree with him, and so that's as close as a trial judge might get to having a dissent, right? We don't have, we didn't write on the same case, but it's the same issue, and I approached it, and when I wrote about it, I didn't write, Judge Mannion's an idiot, and I can say it. Judge Mannion and I are friends, so I'm comfortable saying this. Like, I didn't say he's off his rocker, he doesn't know what he's talking about. I distinguished his case, I noted what he decided, but I ultimately have found the other way. Judge Mannion and Judge Brand have gone back and forth in our court, and again, in a very polite way. They were looking at some Fourth Amendment issues, and they have a disagreement on what the law is. Again, hasn't gone to the circuit, so we are sort of sitting there waiting to hear what might happen, but we disagree politely, and we move about our day. Those dissents, those disagreements in trial courts, whether we're looking at dissents from circuit courts of appeal on other issues, or if we're looking at different outcomes in other district court cases from our colleagues, are really important because they are expanding our minds. When I'm looking at this going, oh, this is a different way of looking at it. And it's really imperative that I open my mind to that, because if I don't, I'm not going to fully grasp and understand all of the ways in which the law might be applied to different facts. And sometimes you learn something that you think, wow, this is different. This is a different way of looking at it, and it might be more applicable in my case than I thought initially. And so that's a really important aspect of the use of dissents and the use of disagreement in our courts. But I will say, and I'll say this, there are lots of different modes of interpretation. We hear about different ways of interpreting the Constitution and different ways of assessing law and assessing facts. But those dissents are really essential to evaluating and testing ideas. And that's why they're useful to the district court. I want to shift then to, what's important about how it's addressed and what it should not be, really. And to follow up on, Professor Oldfather had mentioned who is the intended audience. And I can tell you that speaking for myself, but also speaking for most of the colleagues with whom I've discussed this with, the intended audience of our opinions, especially as trial court judges. I haven't talked to any circuit court judges about this, but as trial court judges, we are writing for the parties. We are writing for the general public who may read our opinions. It's not written to, a judge should be ruling. Our judiciary is founded on this idea that we are independent. It is a political process by which we become a judge, a federal judge, but the politics stop at that point. So when I am deciding a case, I'm writing for the parties who are reading it, and for the general public who may be reading it, and for the lawyers who may read it as they use it possibly in their own cases going forward. And to that end, it's written it should be written in a plain English way. The students of mine who have been interns here know that I talk to them about this all the time. Writing should be plain. It should be understandable by a litigant, whether that litigant has an 8th grade education or a master's of law degree. They should be understanding that this is an important part of their life, and not everything I write is some massively important decision. Sometimes they are really not. Most of them are really not important decisions, but they are important to that person in that case. And it deserves to be viewed with a lens of respect for the law, for the rule of law, and for the parties' claims in that case. And so I think if judges lose sight of that, that's when they begin to shift that nature of that conversation. That's when they become, if they think they're writing for press coverage, or they're writing for someone or a future job, or they're writing for some reason other than to decide a case and to explain that concept, explain the reasoning behind it to the parties in the case, you lose sight of how they should be addressing the issue and the controversy. And so it's my opinion that the audience should always be, for a judge, the parties in the case, the general public, and legal jurisprudence, and not for anything else. Because I think when it becomes anything else, you are inputting into your decision-making process something that doesn't belong there. We take an oath to uphold the Constitution. We take an oath to uphold the rules of law. We take an oath to uphold the laws of the United States. And we take an oath to be able to rule without fear or favor. And if you stick fear or favor into that, you are taking away from the interpretation of the law and the application of the law to the facts in your case. So that being said, tone is important. How issues are addressed are important. And whether you're writing in a dissent or in an opinion, a trial court opinion that disagrees with other district court opinions in your court, or whether you're disagreeing with a circuit decision in another circuit, your tone is important. And I'm not one to have flowery language, in my opinion. But it's it's pretty straightforward. And I think tone is really important with that when you're disagreeing with it. And I'll give you an example. There are a number of cases that I won't comment on specifically because they're pending. And we don't have Third Circuit precedent on this issue. But there is another circuit that has issued an opinion on it. And I disagree with that opinion. It's not binding on me. And so I drop a footnote and I say, the court is aware of this decision and it is not binding on this court, and I decline to follow it. Now, I could say, I have some colleagues who might say, we think that circuit's completely off the wall, and we think they're wrong, and we think that they are going to regret making that decision. But that's not, in my mind, appropriate. The appropriate thing to do is to say, this is just a disagreement. I don't agree with them. It's not binding. Now, look, the Third Circuit could come back next week and say, well, we do, and then I'm wrong, but that's okay. And I won't say, well, I think the Third Circuit's wrong, because I'm bound by that. But that's, knowing what the appropriate tone is important. there is also a time and a place for, I think, pushing that line. But it's really hard to tell where that is. There is a decision out of a district court in Texas recently by a judge there who's sort of known for writing opinions that are a little more, I'd say, creative or poetic, or it's a short opinion, but he talks about putting a hole in the constitutional dike or putting a thumb over the hole in the constitutional dike and trying to stop a number of cases. And he got a lot of feedback on that, negative and positive. People who agree with the outcome of the case were extremely excited and applauded his sort of creative writing. But the people who he found against were pretty unhappy. We do a lot of talking recently, judges who feel comfortable doing it, about and this is going to get into that last section I want to talk about, but about what the appropriate process is when you disagree with an opinion. And as a trial court judge, and you guys all know this, again, I'm probably preaching to the choir here, you know that the process is, I'm unhappy with what Judge Mehalchick did, I'm taking an appeal. You may, in some situations, get on social media and say, I'm unhappy with this decision, we're taking an appeal, I think she's wrong. What's not appropriate is a call to, a call that the judge is a monster, or a call that, saying that judge will regret making that decision. That's not dissent. That is intimidation, it's disinformation, it's threats, and in some cases it becomes violence. And it's a call to arms, and it's a call to action that is not appropriate in dissent. That is not dissent. And so when you have dissents that are written that mock the majority opinion, or you have a trial judge who mocks their colleagues, that's us. That's us as a judicial branch not being any better than the people that we say you shouldn't be talking about us like that. And so you have, you have this need to be professional and to be civil and to have decorum and to reinforce the appropriate process. And that starts with us. That starts with judges realizing that we are going to disagree. We are trying to resolve hard issues. We are human beings, but we have a duty to do it civilly, and we have a duty to do it respectfully. And when you lose that, you really become you lose credibility, I think, when you're doing that. And so it's really important whether you're a trial judge or an appellate judge, I think, and I'm not an appellate judge. I don't intend to ever be an appellate judge. I love being a trial judge, but the trial judge has to be respectful of the litigants, of the parties, and of the precedent that's coming before it, whether they agree with it or not. And because that then shifts to the duties of the attorneys and the litigants to respond to it in that professional and civil manner as well. In 2024, Chief Justice Roberts issued his year-end report, and he said then that, there are four things that are really coming at the judiciary and judicial opinions right now, and it's violence, intimidation, disinformation, and threats. And those four reactions to people or by people who are unhappy with opinions of any court are inappropriate. And I think when you have a trial court writing an opinion or any court writing an opinion that borders on or crosses a line into not the facts of the case, not the law that's before it, not a professional and civil dialogue about what is different, you end up in a situation that is dangerous. And that's where we're at now with the way people react to opinions is they use, they spread disinformation or misinformation, they make threats. threats and intimidation have increased significantly over the last couple years, because people hear and respond to other people saying, we don't like that opinion, that judge is a monster and shouldn't be on the bench. The answer is really I think the judge was wrong and we should appeal her. And none of us are going to care about that. We're here, we have thick skins, that's what happens. But when dissent becomes something that's not a civil conversation, that's when dissent becomes something that is really of concern. But that's not what we are a country built on or founded on. We're a country built on the idea that everyone has their own thoughts, everyone is free to express those thoughts, and we should be able to do so and converse in them in a very civil and peaceful way, and be open to those ideas. And so to follow that idea that Aristotle said was that, the idea that our educated mind is to be able to think about these other points of view, basically, without necessarily having to accept it or being open to changing your mind, is really important. When they got to the end of the Constitutional Convention, I'm going to go back to that, Benjamin Franklin sat there, and the whole convention, he'd been looking at the chair that George Washington sat in as president of the convention. And he said, I have often in the course of the session looked at that sun behind the president without being able to tell whether it was rising or setting. But now at length I have the happiness to know it is a rising and not a setting sun. And the point of that, I think, I wasn't there, I wasn't in Ben Franklin's mind, but the point of that is as he's looking at this chair, this carved wooden chair that George Washington sat in, having sat through months of disagreement, of dissent between each other, of how to form this new country, and how to provide this framework for it, is that this is a moment of positivity, that out of dissent can come really good things. People can disagree, and that's what we are made of, people who disagree. However many people are here in this room, we all have different thoughts, and that's okay. And the idea that the courts have dissents is really important. But I think what's important is that those dissents are professional, that they're civil, that they're not meant to cut each other down, any more than your appeal should be meant to cut down the judicial branch. So that's where I'll leave you. I think we are in a position of a rising sun, and I think that dissents really help with that. Thank you.
Kiera, it's my understanding, correct me if I'm wrong, is my understanding that it is something of a soft stop, right? So we have we've got some play here, right? So Professor Scott, don't panic, right? If my introduction for you goes on too long, that's no, it's a soft stop. You heard it from Kiera. There's no need for dissent. Professor Wendy B. Scott is currently serving as a distinguished visiting professor of law at Widener University's Delaware Law School. Professor Scott brings to the program today a career in legal education that spans over 3 decades and has provided her the opportunity to teach over 2,000 students. Professor Scott is a nationally recognized scholar in constitutional law and school desegregation, and she and her co-author, Linda Green, will soon publish Thurgood Marshall, J., Dissenting, a roadmap for an inclusive constitutional democracy with Carolina Academic Press. Prior to joining the faculty at Widener, Delaware, Professor Scott not only taught at numerous law schools, but also served as, and I'm going through this because you did it, so you ought to get credit for it, served as Dean at Henry Vaughan Watkins and Shelby Watkins McCrae Professor at Mississippi College School of Law, Associate Dean for Academic Affairs at North Carolina Central University School of Law, Vice Dean for Academic Affairs at Tulane Law School, and Associate Dean of Academic Success at Elon University School of Law. Professor Scott has also practiced labor, employment, and civil rights law at the Medgar Evers College Center for Law and Social Justice, the Vladeck Law Firm, and the Legal Action Center of New York. Professor Scott.
still morning. Good morning. It's a delight to be here, and thank you for that introduction. Thank you, soon-to-be Attorney Flannery and your staff for this wonderful event. Thank you, Dean Cummings, for giving a little preview of my presentation this morning. Given the time constraint, Professor Gailey and I wondered if I should make up for the time by talking fast, but I won't do that. And what I'm going to do, though, is share an excerpt from our forthcoming book on the dissenting opinions of Justice Thurgood Marshall. When Justice Thurgood Marshall retired from the U.S. Supreme Court in 1991, one editorial described his jurisprudence as a collection of thundering dissents to the rising conservatism of the court. Other journalists described Marshall as an isolated voice of egalitarian fairness and a consistent and eloquent champion for the downtrodden. Marshall's admirers hoped that his legacy of dissent would be vindicated in the larger forum of history. The work of Thurgood Marshall as both a lawyer and a judge illustrates his effective use of oppositional countervisions of law that had been necessary to secure the rights and liberties afforded under the United States Constitution. Dissent, in Justice Marshall's hands, was both a cry against indifference and a message of encouragement. Justice Marshall's record as a lawyer and a jurist demonstrates that his dissent can be seen as hopeful, responsive ways to address skepticism. In one of his last speeches, he urged the necessity of dissent for a society worthy of the aspirational model, we the people. Marshall said this, quote, "We must dissent from indifference. We must dissent from apathy. We must dissent from fear, hatred, and mistrust. We must dissent from a nation that has buried its head in the sand, waiting in vain for the needs of its poor, its elderly, and its sick to disappear and just blow away. We must dissent from the poverty of vision and the absence of moral leadership. We must dissent because America can do better, because America has no choice but to do better." Marshall also viewed dissent as necessary to the creation of a democracy founded on liberty and justice. In that same speech, he concluded, quote, "Democracy just cannot flourish amid fear. Liberty cannot bloom amid hate. Justice cannot take root amid rage. In the chill climate in which we live, we must go against the prevailing wind," unquote. Marshall's dissenting opinions have left a record in the annals of American history, and America's highest court, which together construct a democracy that envisions racial and economic justice, gender equality, robust First Amendment rights, and the fair administration of justice in the criminal system, including the abolition of the death penalty. So today, I would like to briefly explore the question, what shaped Justice Marshall into one of the great dissenting justices of the Supreme Court? Marshall's life, experience, education, and years of practice laid the foundation for the expansive view of equality, individual rights, and liberties that he would later espouse from the bench of the court. The late Judge Leon Higginbotham of the U.S. Court of Appeals for the Third Circuit explained how Marshall's judicial philosophy had been shaped in what he described as the crucible of human suffering. Justice Marshall, he said, quote, brought a special perspective. He was the eye of a lawyer who saw the deepest wounds in the social fabric and used law to help heal them. His was the ear of a counselor who understood the vulnerabilities of the accused and established safeguards for their protection. His was the mouth of a man who knew the anguish of the silenced and gave them voice, unquote. Born in 1908, Marshall was raised by a generation of parents who were the children of slaves. The grandson of a slave himself, Marshall grew up in segregated Baltimore, where he experienced the coercive brunt of Supreme Court decisions like Plessy that constitutionalized Jim Crow second-class citizenship. By the time of Marshall's birth, the federal government had repeatedly broken the promise of promoting racial equality embedded in the Reconstruction Amendments and allowed racial oppression to flourish. White Americans in the South and the North were violently resisting Black social and economic progress during Marshall's childhood. Race riots in several parts of the country, the lynching of Black men and women, and the destruction of Black-owned businesses and residents became part of the fabric of American life. But the turn of the century also witnessed the development of cohesive Black political, religious, and fraternal organizations in response to the heavy weight of racial oppression and violence. In 1905, W.E.B. Du Bois and William Monroe Trotter founded the Niagara Movement, which laid the foundation for the creation of the National Association for the Advancement of Colored People, the NAACP, the organization through which Marshall would later craft the strategy to kill Jim Crow. During Marshall's formative years, the second oldest branch of the NAACP thrived in Baltimore. Marshall grew up in a community that, despite being caught in the throes of economic, social, racial, and jurisprudential oppression, resisted at every turn. He attended all segregated schools where he was well educated and developed a sense of pride and self-confidence in the crucible that shaped his life and legacy. And as we would later see in his campaign to overrule Plessy, he had developed a deep respect for education as a primary means for fueling the future that would surround his experience. Lynching occurred in Maryland during Marshall's childhood, but despite living in the shadow of terror, those who served as role models for Marshall and others kept the spirit of resistance alive through those violent and precarious times. As a student, Marshall began his legal studies under the tutelage of Charles Hamilton Houston at Howard Law School. Houston attended Harvard Law School during the era when the foundation for legal realism was being laid. Proponents of legal realism claimed that law consisted of indeterminate and not immutable rules and reasons. The common theme in this developing school of thought was the belief in the potential for the improvement of human society and the human condition through purposeful change imposed through political and legal means. Houston described legal realism this way: a scientific approach to understanding law, skepticism about the objectivity of legal rules and concepts, an understanding of rules and legal concepts in terms of their social consequences, a recognition of law as a mechanism for implementing social change, and a clear preference for pragmatic, workable solutions over unanchored, idealistic theorizing. As Dean Cummings noted, Houston transformed his formulations of the tenets of legal realism into what one author called the Black jurisprudential matrix, to create a cadre of social engineers that would secure fair and equal treatment for African Americans. He turned this sociological jurisprudence into action as a law professor and became the chief architect to overrule Plessy versus Ferguson. The greatest of Houston's social engineers was Thurgood Marshall. The inculcation of the tenets of legal realism into Marshall's legal education and practice presumably shaped his thinking on constitutional interpretation. Marshall seemingly agreed with legal realism's emphasis on law responding to changing social norms. His approach to the practice of law illustrated the teaching that fluid social and political change should influence judicial precedent as courts work to secure the viability of legal doctrine over time. Marshall's education prepared him to enter the legal profession ready to advance the mission of dismantling the systemic and stigmatizing racial subordination he experienced firsthand. He became the social engineer envisioned by Houston as the leader of the NAACP cadre of lawyers. The mission of these lawyers? To lawyer for social justice as a mechanized army, fighting to secure the justice and equality promised to all citizens, but too frequently denied to the poor, minorities, and indigent criminal defendants. During Marshall's tenure as chief counsel for the NAACP, they continued with a full docket of criminal defense cases, cases dealing with the right to vote, to serve on juries, exclusion from public accommodations, housing discrimination, anti-miscegenation laws, and the discriminatory application of the death penalty. They also worked against the use of the criminal justice system to oppress Black citizens, lynching, and workers' rights. The focal point, however, was the litigation campaign initiated under Houston and continued by Marshall to undermine the foundational legal assumptions of Plessy versus Ferguson that separate could produce equality and not stigmatize African Americans. On the bench, Marshall chose carefully when to use the jurisprudential power of dissent to propose alternative judicial approaches that would achieve a more fair and just treatment of subordinated groups. During his early years on the court, Marshall joined the majority opinion in most cases, and of course he joined the court when Earl Warren was Chief Justice. His work overall demonstrated his belief in unanimity, in precedent, in consensus, and in compromise during his 24 years on the court. However, when the court's majority did not protect important individual interests or vulnerable groups, or failed to foster vigorous debate or an inclusive polity, Marshall dissented. But he did more than dissent to offer different legal standards or outcomes. Marshall bequeathed to the world the stories of America from the perspective of the economically and politically powerless to strengthen his call for inclusive justice for all. Marshall's dissenting opinions have revealed to us his consistency in challenging the structural oppression experienced by people to whom Marshall gave voice. His opinions explained how the dominant jurisprudence permitted governments to exacerbate the conditions that fostered discrimination and subordination and ignored threats to judicial integrity that weakened the counter-majoritarian function of the court. Throughout, these dissents connect hidden histories with the contemporary experiences of the people the court adversely affected by its rulings. He used dissent as an opportunity to flesh out the factual record, to identify and to illustrate the systemic effects of government abuse of power. Whatever the issue, whether it was the constitutionality of the death penalty, affirmative action, abortion, financial security, education, access to justice in civil suits, or the right of criminal defendants, Marshall was concerned consistently with indifference to those most vulnerable to the vicissitudes of government power. These opinions also preserve his efforts to expand liberty and equality for racial minorities, women, the poor, and ultimately for all Americans. Marshall also advocated guarding against the sudden erosion of precedent and the avoidance of summary dispositions of cases, which is on the rise, to maintain actual and the appearance of judicial integrity. His judicial writings are especially supportive of ensuring equality and due process in the diverse society America has become. His assurance that America can be an inclusive constitutional democracy is embodied in prodigious, mostly dissenting opinions worthy of sustained attention and careful study. His dissents provide the constitutional framework for Marshall's We the People constitutional paradigm shift that we will have constructed throughout our book. Finally, Marshall adeptly used the history of and empirical evidence regarding the lived experiences of poor and powerless people to support the vigilant protection of these rights. Marshall's steadfast belief in the Constitution as the pillar of democratic and egalitarian principles, and in law generally as a protector of the poor and the powerless, reminds the American people of our vast potential for social progress. In the words of Judge Higginbotham, I'll conclude, he says this about Marshall: Justice Marshall taught us that none will determine your place in history as much as your defense of the weak, the poor, minorities, women, the disabled, and the powerless. Keeping his plea and his voice resonant may be the most important contribution you could ever make in your life to the American legal process. And so I'll leave you with a charge that I believe Justice Marshall would leave with all of us. And that is to protect our democracy from the risk of injustice, inequality, and the loss of our freedoms. Thank you.
Although we are on the brink of lunch, if I can hold things up for just a couple of minutes, Kiera, with your patience. Couple thank yous I think are absolutely necessary. One is a thank you to the law review staff and to Kiera for making this so easy and well organized that even I could not mess it up. The second thing, and probably actually the most important group of people I want to thank, Billy Joel once, as a paraphrase, made the observation, the quality of the performer is a function of the quality of the audience. And we have had a good presentation today because you have been a remarkably good audience. And I really, really appreciate, one, you being here, and two, your level of engagement. And so if you had a good time, you had a good time because you guys are a great audience. Thank you to three wonderful speakers who actually rose in my mind a very surprising and provocative thought that I want to leave you with. And this is amongst the many things that you guys raised, a theme that I saw coming through each of your presentations. And I did not expect to end up here, but this is where I ended up, so it's your fault. But what I heard coming through your talks is the workability of dissent is not just a function of the how or the what, but it is a function of the personas of the who's, both the dissenter and the majority. If those peoples or those personas are not excellent, then the process does not work. And I want to thank each of the panelists for the excellent who that you all bring to this process. And I also want to thank, or to caution all the students and lawyers here to take very good care of the who that you are, because it does matter deeply. Thank you all for your participation.
I can sit right around here.
If you guys want to sit over there so you can eat your lunch or whatever.
Stay right there. We've been evicted.
No. If you wanted, I don't know if you want to eat your lunch or anything.
Well, I told Professor Power to sit here.
Okay.
He's going to make me. But, you know, I think it's fine.
Okay.
We sit over there. If you think we should.
You are a master of administrative tasks, so
Yeah,
I'm going to defer to your judgment.
We can have, if you guys would like to eat your lunch, you can sit over there and then move over. It's up to you. It's completely up to you all.
I'm afraid of picking my nose on
But we do want you back up here.
We
For the
will.
question. Hi, everyone. If we could get started, if everyone could please take their seats. Welcome to our highly anticipated keynote address, Dean Erwin Chemerinsky. Before we begin, I want to explain how the Q&A portion of this talk will work. You should each see a question slip at your seats. To streamline questions and ensure we can get to as many people as possible, we ask that you write down your questions in advance. At the conclusion of Dean Chemerinsky's talk, law review members will come around to collect your questions, and our moderators, Professor Power, Professor Chauvin, and Professor Lee, will move up here and will read out your name and questions in addition to any of their own. If you could, at the conclusion of the remarks, pass your questions inward so that our law review members can come and collect them in these two rows, we would greatly appreciate it. We thank you for your assistance. Now, on to the exciting part. Erwin Chemerinsky became the dean of UC Berkeley School of Law after joining the faculty as a distinguished professor of law in 2017. He received his Bachelor of Science at Northwestern University and his JD at Harvard Law School. Prior to assuming this role, he held numerous positions in academia, including as the founding dean and distinguished professor of law at the University of California, Irvine School of Law. He is the author of 22 books, including leading case books and treatises about constitutional law, criminal procedure, and federal jurisdiction. He is also the author of more than 200 law review articles. He is a contributing writer for the opinion section of the Los Angeles Times and writes regular columns for the ABA Journal and the Daily Journal and frequent op-eds in newspapers across the country. He frequently argues appellate cases, including in the United States Supreme Court. In 2022, he was the president of the Association of American Law Schools, and in 2024, National Jurist magazine again named Dean Chemerinsky as the most influential person in legal education in the United States. It is an understatement to say that Dean Chemerinsky has had an incredible career. That is why, when we first invited him to serve as our keynote speaker at this symposium, we knew his time would already be in high demand across the legal community. When he accepted my invitation within minutes, I was struck by his enthusiasm and his generosity with his time. That is a true testament to his character and career. This is someone who has dedicated his life to championing the causes that we are here to discuss today, and we thank him so much for joining us. Without further ado, Dean Erwin Chemerinsky.
Thank you so much. Let me just ask, can you hear me okay? Could someone wave or signal just that you can hear me? We're okay? I'll take that wave as a yes, so thank you. Thank you so much for the incredibly kind introduction, and thank you for inviting me to speak. I'm deeply honored to have been asked to do this keynote. I wish that I could be with you in person, but as was indicated, because of other commitments, I needed to be in California today. And I'm so glad that technology makes it possible for me to at least talk with you remotely. I regularly teach First Amendment law. In the class, I constantly say to my students that we don't need the First Amendment to protect the speech that we like. Any society would allow that to go on anyway. What we need the First Amendment to protect is the speech that we dislike, or the speech even that we detest. The reality is, not just throughout American history, but throughout world history, there's always a desire to stop the speech that we don't like, to stop the speech that we find offensive. We can point to instances in our society today, or throughout American history, where there are efforts to prohibit, to censor speech that a particular group dislikes. And it's not political. There are instances where liberals have tried to do this, and instances where conservatives try to do this. And history shows that those in power frequently want to use that authority to stop criticism. They want to stifle dissent. We all know that it's a characteristic of an authoritarian society that the dictator will try to stop criticism. Just think of what Vladimir Putin does in Russia and what happens to dissenters and dissidents there. What I want to talk about is dissent in American history and today. The reality is that the United States, for all of its commitment to freedom of speech, has a very mixed record with regard to dissent. I'd like to make 3 points in my remarks this morning. First, I want to look at history and talk about the historical failure to protect dissent in many crucial moments in time. I also want to recognize the instances in which dissent has gone forward and has made a huge difference in our society. Second, I want to talk about the special role of universities with regard to dissent. This, after all, is a university conference. I work in a university, and so we should talk about universities relative to dissent. And third, I want to talk about what gives me hope for now and for the future with regard to dissent. There will always be the impulse of those in power to stifle or to stop criticism. But I think we are better situated at this moment in time to withstand that in the United States than we've ever been before. So as to my first point, I want to look at history. The First Amendment was adopted in 1791. It's written in seemingly absolute terms that Congress shall make no law. And of course, it applies to much more than Congress. And no law has never meant no law, but it certainly expresses a strong commitment by those who wrote the First Amendment and ultimately those responsible for the Constitution to protect freedom of speech. And yet, if you look through American history, especially at times of crisis, there have been concerted efforts to stifle dissent. And in a conference that's focusing on dissent, we need to talk about these. Let me briefly go through many examples of this, though I know they're familiar to everyone in the room and everyone who's watching. The effort to stifle dissent started early in American history when Congress passed the Alien and Sedition Act, 1798. Remember that Congress in 1798 still had many people in it who had been part of drafting and ratifying the First Amendment 7 years earlier, or drafting and ratifying the Constitution 11 years earlier. These were the framers, if we're going to talk about framers' intent. And yet the law that they passed seems inimical to what the First Amendment or even democracy is about. The Alien Sedition Act made it a crime to falsely criticize the government or government officials. Individuals were prosecuted and convicted for speech much milder than we would see regularly now in monologues on late night television. When Thomas Jefferson ran for president in 1800, in part he did so on a platform of repealing the Alien Sedition Act, promised to pardon those who've been convicted under it, because those who've been convicted were being punished for their dissent. The Adams administration used this law as a way to try to stifle dissent and to punish dissenters. Thomas Jefferson, of course, was elected in 1800. He did pardon those who'd been convicted under the Alien and Sedition Act. Congress repealed the Alien Sedition Act. It is hard to imagine a law more inconsistent with the letter and spirit of the First Amendment than this one, and yet it was adopted just years after the ratification of the First Amendment. The Alien Sedition Act was never actually declared unconstitutional. In 1964, in New York Times versus Sullivan, the Supreme Court said that the Alien and Sedition Act had been declared unconstitutional, quote, by the court of history. It's a wonderfully romantic metaphor to think of the court of history. But the reality is, people went to prison just for their criticism of the government. We often forget that during the Civil War, President Abraham Lincoln very much tried to stifle dissent. Jeff Stone, professor at the University of Chicago Law School, has written a terrific book called Perilous Times, and in it he describes the efforts of repression in times of crisis. He details how Lincoln punished those who criticized the Civil War. People again went to prison just for objecting to the way the North was acting. And after the Civil War, during Reconstruction, we saw the same thing, a concerted effort to punish those who were criticizing what the government was doing. Perhaps in your constitutional law classes, maybe federal courts, you read a case from that Reconstruction period, Ex parte McCardle. McCardle was a newspaper editor in Vicksburg, Mississippi. He opposed Reconstruction, and he believed that people should not participate in the elections being created under the Reconstruction Authority. For this, he was arrested and imprisoned. just for the editorials that he wrote. And he went to the Supreme Court on a writ of habeas corpus. Congress repealed its newly enacted habeas corpus statute rather than let McArdle get his day in the Supreme Court and risk that the Supreme Court would strike down Reconstruction. That's yet another example of dissent being punished in this country's history. World War I was a time when, again, there was very much a concerted effort on the part of the federal government to punish dissenters and thus to silence dissenters. We perhaps forget, unless we look back at history, that World War I was very unpopular. The United States in the time of George Washington had believed that we were protected from involvement in foreign wars by the two great oceans. There was no need for the United States to be involved in a war in Europe. As a result, dissent developed through the United States. Congress passed two statutes in 1917 and in 1918 try to curtail that dissent. The first major Supreme Court cases to ever deal with the First Amendment arose under the 1917 and 1918 statutes. And if you've taken First Amendment law, you're familiar with these cases. You've read undoubtedly Schenck versus United States. And it involved an individual who circulated leaflets that said, quote, "Do not submit to intimidation." In the leaflets, he argued that the military draft conscription was a violation of the 13th Amendment. It was involuntary servitude. We can agree or disagree with Schenck's argument, but it certainly was what today we would call political speech. There wasn't a shred of evidence that Schenck's leaflets had the slightest adverse effect on military recruitment. No indication that a single person didn't report for induction because of Schenck's leaflet. Nonetheless, the Supreme Court ruled against Schenck and upheld his long prison sentence. Justice Oliver Wendell Holmes wrote the opinion for the court. This is with a case where he famously said, "There's no right to falsely shout fire in a crowded theater." This is the case where he said that the government can punish speech if there's a clear and present danger of harm. But Schenck's leaflet is the antithesis of clear and present danger of harm. Clear and present danger connotes that there is an immediate threat of a serious risk. Schenck's was a political argument. If you studied First Amendment law, you read other cases from the same time period, 1919. That year, in addition to Schenck, the court decided a case called andré Debs, case Debs versus the United States. What was involved here was Eugene Debs was the socialist leader, and he gave a speech to a college audience, and he said to them, quote, "You are good for more than cannon fodder. There's more that I'd like to say to you, but I can't." Just for saying that, he was convicted, sentenced to a long term in prison. And in the case of Debs, the Supreme Court ruled in favor of the United States government, saying that he could be punished for this dissent. To me, it is impossible to reconcile cases like Schenck and Debs and others from the time, Frowork and Abrams, with the basic notion of that the First Amendment protects the right to criticize what the government's doing, including in wartime. During World War II, there weren't major cases to come to the Supreme Court involving dissent itself. Likely that's because there was much less in the way of organized dissent to World War II than there was to World War I. But soon after World War II, the McCarthy era developed. It was very much the age of suspicion. Merely to be suspected of being a communist would cause people to lose their jobs and sometimes even their liberty. It takes its name, as you know, from a senator from Wisconsin, Joseph McCarthy, who used the campaign against communism to smear people without any evidence, any factual basis. Well, the Supreme Court, in the midst of the McCarthy anti-communist hysteria, had cases come to it. And the most important case was Dennis versus the United States. And any discussion about Supreme Court and dissent, well, the Supreme Court in speech has to look at Dennis. You have to read the dissenting opinion in Dennis to even understand what the individuals were convicted of. The individuals were prosecuted and convicted of organizing to teach the works of Marx and Lenin and Engels. For this, they were prosecuted and convicted under the Smith Act, federal law that makes it a crime to advocate the overthrow of the United States government by force or violence. Now, there was not an iota of evidence that these individuals teaching the work of Marx, Lenin, and Engels posed any threat to national security. As Justice Douglas eloquently said in his dissent, there's no reason to believe that those in the United States are going to adopt the much discredited theory of communism. Nonetheless, the Supreme Court ruled against Dennis and the co-defendants. The Supreme Court upheld their prison sentences. Chief Justice Fred Vinson wrote the opinion for the court. And he said, when the harm is as grave as the overthrow of the United States government, there shouldn't have to be any proof of risk or imminence in order to sustain a conviction. Justice Felix Frankfurter wrote a concurring opinion saying that the government should be able to punish speech so long as the government meets a rational basis test. Dennis, of course, if followed, would very much punish dissenting speech. And certainly it stifled a great deal of speech that was dissenting from what the government was doing, dissenting from our system with regard to economics and politics. And the McCarthy era lasted for many years, and it was fueled by the Supreme Court's decision in Dennis. During the Vietnam War, there were many protests against it, especially at colleges across the country. I participated in anti-Vietnam War protests when I was in college. And to a large extent, our society tolerated and accepted those protests. But the Supreme Court's track record, even here, was mixed with regard to how it treated dissent. I'd point your attention to what I regard as a very important and very distressing case with regard to speech and dissent, and that's United States versus O'Brien in 1968. As you know, the Vietnam War was terribly unpopular. In part, it was unpopular because there was a military draft. When I was in college, the most frequent conversation late night in the dorm is what we would do if we got a low draft number and we were drafted. Would we go? Would we try to get a medical exemption? Would we even exacerbate a medical condition to get an exemption? Would we flee to Canada? And I know people who chose all of those paths. One of the powerful ways that people protested against the Vietnam War was to burn their draft cards. And a draft card was a piece of cardboard, a little smaller than a credit card. And it was thin, flimsy cardboard. And it stated your name, stated your draft registration. 1A, for example, meant you were eligible for draft. 4F meant a medical exemption, and so on. And it had instructions in the back where your draft board was located and to let them know if you moved. And men began in protests burning their draft cards. It was a powerful visual image, and it was important to capture attention on the nightly news. So Congress passed a law that made it a crime for men to burn their draft cards. There's no doubt that the motive of Congress was to stop this form of dissent. David O'Brien stood on the state capitol courthouse steps in Boston and burned his draft card and was prosecuted under this law. I would think that a Supreme Court committed to protecting dissent would have said, this is speech protected by the First Amendment. There's no reason why he needs to have the copy of his draft card. In 1968 was when we had the most liberal Supreme Court in history. This was the Warren Court, where it had a solid liberal majority. But the Supreme Court ruled against David O'Brien. The Supreme Court said that prohibiting the burning of draft cards only has, quote, an incidental effect on speech. The court said as a result, it was not going to use strict scrutiny, but instead giving the government the ability to regulate for having an important interest. And the court manufactured important interests, like it was important to men to have their draft cards so that they would have a reminder to contact the government if they moved. That if there's a need for emergency military mobilization, the court said, this would facilitate it, but not at all sure how it would be. And so even with the most liberal court, at a time of extensive protest and dissent, the Supreme Court upheld the government's action. Perhaps most troubling in O'Brien is at the end of the opinion, Chief Justice Warren says that the motive of Congress doesn't matter. Of course, the motive of the government should matter. The Supreme Court has said in many instances, if the government acts with the motive of stopping a particular message from being expressed, the motive of a content-based restriction, then it's going to have to meet strict scrutiny. Again, now what we see is a government that's trying to stop protests. We saw just weeks ago the aggressive efforts by the government to stop the anti-ICE protests in Minneapolis. And to pick an even more recent example, just last weekend, the chair of the Federal Communication Commission said that broadcast stations could face license revocation if they didn't provide what government regarded as sufficiently fair coverage of the Iran war. And of course, in the eyes of the Trump administration, only praise is sufficiently fair coverage of the Iran war. And nonetheless, the chair of the FCC threatened revocation of broadcast licenses for stations that didn't meet their definition of the public interest. Under the First Amendment, no broadcast station can have its license revoked for the positions that it takes, the ideology that it expresses. I think there's a strong argument that what Carr was doing itself violates the First Amendment. The Supreme Court has made it clear that government threats of prosecution are sufficient for an infringement. So I have quickly sketched many instances in history where the government has failed, where the courts have failed to adequately protect dissent. These are highlights. There's certainly many others. But I don't want to overstate this either. There are certainly plenty of instances in American history where dissent has occurred and dissent has really mattered. I think of the demonstrations in the first part of the 20th century to accord women the right to vote. Women's suffrage was an enormously important movement. It literally led to demonstrations in the streets. And the 19th Amendment, adopted in 1920, that accords women the right to vote, was a result of dissenters saying it is just wrong to deny the right to vote on account of sex. In the early part of the 20th century, there were many instances of successful labor protests. And we can find examples from then until now, where unions holding sit-ins, unions picketing, put sufficient pressure is to really make a difference. One of the most important examples where dissent worked was with regard to the civil rights demonstrations of the late 1950s and early 1960s. These were protests to dissent from the laws that required segregation of the races in all aspects of Southern life and aspects of life in many other states as well. All of the techniques that were used, the sit-ins, the marches, the demonstrations, made an enormous difference. I don't think the 1964 Civil Rights Act or the 1965 Voting Rights Act would have been adopted without the protests that preceded them. The civil rights protests made such an enormous difference in truly transforming society. I think the most recent extensive protests in the United States were in 2020, after the tragic death of George Floyd in Minnesota in late May. At that time, in the midst of COVID, there were major demonstrations in every one of the 50 states. These were demonstrations against police abuse. These were protests to urge police reform. And I can give you examples of how these demonstrations succeeded. There are instances of police reforms that were adopted following them, though I think it was much less than many had hoped at the time. So that's my quick historical overview. Let me shift to the second part of my remarks, and I want to talk about the role of universities, because I think that universities play such a crucial place with regard to dissent. I think in talking about universities, we need to recognize that there have been two very different conceptions of universities. There was a 19th century conception of universities. They were very much controlled by administrators, often by a church. And it was thought that those who controlled the university could also determine what speech would be allowed within it. Those who controlled the university would prescribe the curriculum. Those who controlled the university would be able, same time, to regulate the speech that went on within the university. This began to change early in the 20th century, and the idea of academic freedom began to develop. A very different conception of a university emerged. The idea was that the university should be a place where all ideas and views can be expressed. The conception of the university was that it very much could be a place where dissent could take place and even thrive. In 1915, the American Association of University Professors released its first statement of principles with regard to academic freedom. The AAUP said that instructors have freedom in their teaching, their research and scholarship, and their dissemination of ideas to the public, so long as they are within professional standards. As academic freedom came to be more widely accepted and respected, so did the First Amendment in its law develop. After all, remember that the First Amendment wasn't applied to state local governments for the first time until 1925 in Gitlow versus New York. So there's no occasion to apply the First Amendment to universities prior to that. And there was very little in the way of federal action that led to First Amendment challenges. So the law of the First Amendment was largely undeveloped until well into the 20th century. Protests certainly began to develop on college campuses from time to time, sometimes with regard to labor, later with regard to civil rights, and of course, the Vietnam War. The McCarthy era took a real toll on academic freedom and protests within campuses. University administrators very much capitulated to the pressures of McCarthyism. The president of Yale University said during the time of McCarthyism, Yale will never fire somebody for being communist because Yale will never hire somebody who's communist. There was an ideological litmus test. As I said, just being suspected of being a communist was sufficient for someone to lose their job. And universities didn't stand up to the pressure. Courts didn't stand up to the pressure. Campuses played a key role with regard to the civil rights movement. Campuses were a place where there were civil rights demonstrators. Individuals were recruited to be freedom riders, to go to states like Mississippi, to register people to vote on campuses. But campuses weren't the only location for civil rights protests. As I said, everyone's familiar with with the lunch counter sit-ins, the marches and the demonstrations. I've already alluded to the importance of campuses with regard to the Vietnam War. More than at any other point in American history, campuses were the focal point with regard to dissent. But it didn't come easily. I want to speak of my own campus, the University of California at Berkeley. In 1964 and in 1965, there were efforts of students here to engage in protests. In fact, one of the original ones was a group of students who wanted to organize on campus to support Barry Goldwater for the Republican nomination for president in 1964. By 1965, there were efforts to have anti-war protests on campus. The University of California took the position, though, that the only speech that would be allowed on campus was that directly related to the campus, and that there couldn't be protests, civil rights protests, anti-war protests on campus. The free speech movement that developed at Berkeley in 1965, led by a man by Mario Savio, was all about the right of students to be able to use a campus to express their views. The free speech movement was successful. The free speech movement led to a change in policies, not just for the University of California at Berkeley, the home of the free speech movement, but campuses across the country. We all accept that campuses can be a place where students can demonstrate, even if it's not about university policy, even as against what the government is doing. The anti-Vietnam War protests were allowed to occur across the country, but sometimes with grave consequences. On May 4th, 1970, there was a protest at Kent State University, and National Guardmen shot and killed 4 protesters. Campuses across the country were shut down in May 1970 by protests, all as a result of the reaction to the government escalating the war in Vietnam, reacting to the death of the 4 individuals at Kent State. With regard to the protests after the death of George Floyd, those were much less on campuses, and that was because of COVID. By May of 2020, many campuses had shut down because of COVID. Many had already had students go home. But there was another wave of protest in campuses in the spring of 2024. At over 100 universities, pro-Palestinian demonstrations took place, including putting up encampments. And universities, as you know, reacted differently to those encampments. There were protests, including disruptive protests, at commencement ceremonies in May of 2024. And that includes at mine at Berkeley Law. But I think that these protests that occurred in the spring of 2024, probably the most extensive since the Vietnam War, were all about the importance of universities as a place for dissent. Here, dissent from the policies that supported Israel and urging universities to divest from Israel. I worry that now we're in many places shifting to a very different conception of a university, shifting back to a 19th century version where universities have much control over speech. You might have read in January of this year, a Texas A&M professor, Martin Peterson, was told that he wasn't allowed to teach Plato in his philosophy class because of Plato's writings with regard to gender identity. The University of Texas has now adopted a protocol where all professors have to have their syllabi cleared by administrators. Or you might have heard of another instance in January. It involved the University of South Carolina law professor and associate dean, Emily Susky. She interviewed for and was offered the deanship at the University of Arkansas Law School. It was announced by the school. Just a couple of days later, Susky was fired. Susky had signed on to an amicus brief in the Supreme Court in one of the cases involving whether states can prohibit transgender girls and women from participating in girls and women's sports. The brief that Susky signed on to actually didn't take a position as to the constitutional laws, just said the case should be remanded to the lower court for more fact-finding. But for just taking that position, Arkansas legislators said they would cut funding to law school if Susky was the dean and Susky was fired. States like Georgia, Indiana are very much weakening tenure for faculty. I think this is a shift trying to give much more control to university and their administrators over faculty and student speech. Think of the Stop Woke Act adopted in Florida. This, I think, is going to have a detrimental effect on dissent on these campuses when the university itself is imposing an orthodoxy and taking out self-punishing those who disagree. We saw examples of this in the fall, where after the death of Charles Kirk, there were faculty members who spoke out, who got fired, students who faced discipline for what would be regarded as a dissenting view. Well, let me move to the third and final part of my remarks, and that's what gives me hope. I'm often asked at this moment in time, that in many ways is discouraging, what's a source of hope? And I believe that we should have hope with regard to protecting dissent in the future. Why do I say that? Well, one reason is we have a much more robust First Amendment than we've ever had before in American history. Remember, from 1791, when the First Amendment was adopted, all the way until 1919, there were very few cases about the First Amendment. First Amendment didn't apply to state and local governments till 1925, and there weren't many actions of the federal government that were getting challenged. And if you look at the Supreme Court from, say, the 1920s, when the First Amendment is incorporated and applied to the states, well into the 1960s, the Supreme Court is hardly protective of speech. But now we have a series of doctrines that I think will provide protection of speech, and to me provides hope for the protection of dissent. It's now clearly established that content-based restrictions on speech, and especially viewpoint restrictions on speech, must meet strict scrutiny. We have much clearer rules for time, place, manner restrictions in terms of when there can be restrictions on where or when speech occurs. I was encouraged by a Supreme Court ruling on December 23rd, 2025 in Trump versus Illinois. It's not a free speech case, but it involved whether or not President Trump had the authority to federalize a state's guard and to send them in the military to quell protests. Obviously, one thing that authoritarians will do is use their military to stop protests. We know that Donald Trump wanted to do this in May 2020 after the death of George Floyd, was told that he lacked the authority to do so. On December 23rd in Trump versus Illinois, the United States Supreme Court 6-3 said that the president cannot federalize the state's guard unless the regular military could not keep order, and only if the regular military could be deployed. And the court pointed to the Posse Comitatus Act from 1878 that limits the ability to use the military for domestic law enforcement purposes. I think keeping the president from using the military to quell dissent is enormously important, being able to protect the ability of dissent and protest in the future. Second, we have a much stronger social culture to protect freedom of speech. I think if you look over the course of American history, earlier there was much more ambivalence about speech. Now speech is likely regarded as the most precious of all constitutional rights. This isn't inconsistent with what I said in my introduction. I think there's always the impulse to try to stop the speech we don't like. There's always the impulse of those in power to use their authority to stifle dissent. But an example of the social culture that embraces speech was the reaction to SEC Chairman Carr's statement last week that broadcast stations could face license revocation if they didn't cover the war in a way the Trump administration liked. Immediately, even conservative members of Congress spoke out against this. Wisconsin Senator Ron Johnson, very conservative, said that this would be unconstitutional and inconsistent with our commitment to freedom of speech. Finally, what gives me hope with regard to the future of dissent is there are just far more media outlets and channels than ever before. I think that the internet, social media are the most important developments with regard to speech since the invention of the printing press. The internet and social media give to anyone the ability to reach a mass audience. It used to be that to reach a large number of people, you had to be rich enough to own a newspaper, get a broadcast station. Now, any of us with a smartphone, or even just access to a modem in a library, can reach a mass audience. At the same time, we all have access to infinite information. It is much harder for the government to stifle dissent when the government can't control who has the ability to speak or what information they can receive. The internet and social media, I think, are going to be crucial in protecting dissent in the future. So while history gives me reason for concern, all of these developments give me reason for hope with regard to protecting dissent. As will be widely celebrated, this is the 250th anniversary of the signing of the Declaration of Independence. When you think about the Declaration of Independence, it's important to remember that it was a document of dissent. There's 27 grievances enumerated in the Declaration of Independence. All are objections to the behavior of the King of England. All are a dissenting voice. So if we celebrate the Declaration of Independence this year, we really should be celebrating dissent. And I think at this moment in time, that creates a responsibility for all of us. 5, 10, 50 years from now, we will be judged for what we did at this moment. We look back on other difficult times in history and judge how people reacted. Will we be condemned by history for our silence and our capitulation in the face of abuses of power? Or will we be celebrated for our dissent, for our resistance? To me, that's the most important question as we think about dissent in the spring of 2026. Thank you so much again for inviting me.
Dean, can you hear us?
I can hear you fine. Can you hear me okay?
Yep. Okay,
Terrific.
here's one question. Is it time to put rid of broadcast licensing entirely? If so, how would that work?
No, we can't get rid of broadcast licensing entirely because we need to make sure that only one person is broadcasting on a particular frequency at that moment in time. That if multiple people were using the same frequency, it would be babble. We couldn't understand any of it. And so the broadcast spectrum to the extent we're still using the broadcast spectrum for radio, I'm speaking here of over-the-air radio, for over-the-air television, has to allocate licenses. But licenses should never be given or taken away on the basis of viewpoint. Never in history has that occurred. That's what makes Chairman Carr's statements so disturbing. But I think what we should make sure is, to the extent there's going to continue to be over-the-air broadcast stations and licenses are necessary, they're not at all based on the ideology, the content of the speech. And we can have a discussion too. It doesn't have to be you're just reading questions. I'm glad if you want to talk about any of this, but also delighted to take questions.
Dean, we have a question from Thea Homan, who asks about, in your remarks, you spoke a lot about visual images, right? For example, the importance of burning a draft card, right? And Thea asks about whether having these visual images, having actions is essential to dissent, and whether the kind of necessity of action to dissent is part of the reason why we see a push to limit free speech at universities.
I think that visual images are crucial to dissent. That a picture can often convey things much better than words can. Symbols can more powerfully convey things than verbal symbols do. And it's, of course, important in rallying people and in communicating a message. Let me make this concrete rather than abstract. And let me talk about one particular form of dissent that the Supreme Court has allowed, and that's burning the American flag. In Texas versus Johnson in 1989, and then the United States versus Eichmann in 1990, the Supreme Court held that there's a First Amendment right to burn a flag as a form of political protest. It's hard to think of many symbols that more powerfully communicate dissent than that. And the Supreme Court, I believe correctly, has said the government can't reserve the flag to just communicate a message of patriotism, that there also has to be the right to use the flag to communicate a message of dissent. Otherwise, it's an impermissible content-based restriction on speech. Visual images get into the news. They go on YouTube. They're on the front page of papers. And so that's why they're so important as a form of speech and as a form of dissent. And not surprisingly, universities might want to try to limit visual images that could communicate dissent, especially dissent that's unpopular or of their policies.
I have a question from Haley Nelson, and Haley asks, limiting dissent is inconsistent with principles relating to free speech, but does the dynamic change, or to what degree does the dynamic change when those dissents contain misrepresentations?
It's a great question, and the general answer is that false speech is protected by the First Amendment, though with very important limits and exceptions. I mentioned in my remarks New York Times versus Sullivan. It was a defamation case. Of course, defamation is false speech that's injurious reputation. The New York Times was held liable by a jury in Alabama for false speech in an ad that was published there. And the Supreme Court ruled in favor of the New York Times. Justice William Brennan wrote the opinion for the court. And he said that the very core of the First Amendment is about protecting open and robust debate. That includes caustic or even vituperative attacks on those who serve in the government. And he said, in order for free speech to survive and to thrive, it needs to have a breathing space. And that is to include protection for some false speech. The Supreme Court followed this up, about a decade and a half ago, with the case United States versus Alvarez. United States versus Alvarez involved a federal statute, the Stolen Valor Act, that made it a federal crime for a person to falsely claim to have received a military honor or decoration. And Javier Alvarez bragged of having won the Medal of Honor at a public meeting, even though he hadn't. He got prosecuted under the law. but the Supreme Court declared the Stolen Valor Act unconstitutional. Justice Kennedy, who wrote the lead opinion for the court, relied on New York Times versus Sullivan, that there is protection for false political speech, and it included what Alvarez did here. Of course, the protection for false speech is not absolute. There's no right to commit perjury in court, lying under oath. False and deceptive advertising is not protected by the First Amendment. But false political speech is protected by the First Amendment, in part for the reasons the court said in New York Times versus Sullivan, to give breathing space, but in part because we generally don't want the government to decide what's true and false in the political arena. We believe the best thing is to let all ideas be expressed and people hear all viewpoints. But I am very troubled by false speech over the internet. False speech now can spread so very quickly. There's studies that talk about how much false speech, even when it's debunked, continues to be believed. I worry about false speech on the eve of an election. AI creating deep fakes, having a candidate portrayed as saying something that the candidate never said. And yet people would watch and listen and see it with their own eyes, hear it with their own ears. And I don't think that anyone's come up with a way of how to, at the same time, deal with false political speech and be true to the Constitution's commitment of open and robust debate about those who hold public office. So I think one of the really hard issues going forward is false speech, but the general answer is false political speech is protected by the First Amendment.
Here's a question from Eli Ziegler. With the federal government being much greater in power and influence than the framers imagined, is the federal government restricting broadcast rights for what it sees as spreading dissent, misinformation, go against the word or spirit of the First Amendment? Or is the government responsible for quality control over the airways that it distributes to assure or ensure that truth is something? Does it matter that the first is a negative right and news always is a form of positive legal government influence?
The First Amendment, as the question says, is a negative liberty. It's a prohibition of what the government can do. And the First Amendment means that the government, when it's engaged in broadcast licensing, cannot decide who to give a license to or whether to revoke a license based on the content of the speech. It's not for the government to decide what's good or bad speech or true or false speech in giving broadcast licenses. That's the long history and tradition. That's what's so troubling about what the chair of the FCC, Brandon Carr, has done. After the death of Charlie Kirk and Jimmy Kimmel gave a monologue, Carr threatened revocation of broadcast stations, the licenses. President Trump gave a statement where he threatened to revoke broadcast station licenses. Carr did that just last week with a coverage of the war in Iran. The government has no authority to do that based on the viewpoint of the speech. For the government to do so based on the viewpoint of the speech would violate the First Amendment. In fact, I want to go even further and suggest to you that the threats themselves by Carr and Trump violate the First Amendment. There was a 1963 Supreme Court case, Banham Books versus Sullivan. A Rhode Island Commission on Morality and Decency had designated books that it found to be inappropriate for minors. And a sheriff went to some bookstores and said, if you sell these books, you can be punished. The Supreme Court said that the threat itself, without any bookstore being prosecuted or convicted, was enough to violate the First Amendment. Just 2 years ago, in National Rifle Association versus Vula, the Supreme Court said unanimously that a business commissioner in New York violated the First Amendment by threatening sanctions against those businesses regulated that continue to do business with the National Rifle Association. Justice Sotomayor for unanimous court said the threat was enough to violate the First Amendment. I think likewise the threats to revoke broadcast licenses violate the First Amendment.
Well, thank you very much. It is 1:45. That is the agreed upon time to end. Those of you who have a class, please go. Uh, I know it's Friday afternoon and the NCAAs are on, but, so thank you very much, Dean Chemerinsky, and for those who are able to stay, we'll see you all in 15 minutes.
Thank you.
Okay, briefly, I might as well show you this. This is my Portland Frog hat that I got on the internet, because the internet is a great source of dissent these days. And it's the Portland Frog rather than like Kermit or someone, because it's the same. It's got the blue neckerchief. This is the protest from Portland. You can't, well, as I discovered, you can't wear this and vote, because the polling places is one of those channels in which they are allowed to suppress your speech. And this is, the Portland Frog is one of the symbols of the resistance to ICE. It also says resist on the side. That was the only thing that the guard at the polling place noticed, and he didn't think that was appropriate. And under Pennsylvania law, it isn't. So I had to put it back in my car in order to come back and vote. So this is the third panel looking at this problem from another slightly different perspective. We'll have three speakers. I'll introduce them in order. Michael Dimino is a professor here at Widener Commonwealth. He's a graduate of Harvard Law School. After graduation, he clerked on the highest court in New York State, followed by 2 federal clerkships. He's authored numerous articles on constitutional law and election law, and he has won several awards for his teaching and his scholarship. Professor Dimino.
Thank you, Bob. Thanks to all of you for coming. Thanks to the Law Review for organizing the symposium and for the invitation to be here. Thanks also to Alan and Lauren for being part of this panel. It's an honor and a pleasure. I'm going to talk about political violence and the relationship of speech to political violence. And although I'm very happy to be here, I'm not terribly happy to have to talk about this topic. That I am frankly concerned about the state of the United States and where the country may be heading, because what appears to be an increase in political violence, and perhaps even more concerning, an increase in our toleration of political violence, seems to me to put the country on a very bad track. And I wonder not to, although we're going to talk about the evolution of political dissent, I didn't figure that you'd want to go back to the 130s BC, but I am troubled by what might seem an analogous circumstance to the fall of the Roman Republic, and what, to greatly oversimplify a story that took 100 years to develop, the beginning of the end of the Roman Republic, at least under my interpretation of it, was Roman society's acceptance of political violence as a tool of politics. And I think that we're in a dangerous position for accepting that in our society, and I hope that there's enough time to turn it around. So, since I'm a law professor, I should start with some law and some doctrine, and talk about Brandenburg versus Ohio. So our current standard for deciding whether speech that might be seen as inciting violence is constitutionally protected comes from Brandenburg. And the test is that you can punish incitements to violence only if the statements are intended to and likely to produce imminent lawless action. So there's an intent requirement, likelihood requirement, but most importantly, there's an imminence requirement. So even if we say, well, your statement is intended to produce a kind of state of unrest and eventually lead to a state of violent chaos or revolution unless that violence is likely and intended to occur almost now. It's constitutionally protected. We've seen a lot of constitutionally protected speech that falls within that kind of category. But there's a big difference, at least I would argue, between speech that is constitutionally protected and speech that is wise or helpful. Dissent overall, however, is not only helpful, but fundamentally essential to the republic. You cannot have a self-governing democracy without an exchange of differing views on important public issues. And so without kind of right to dissent, there isn't much of a right to govern the society. So how do we balance these different concerns? Certainly preventing violence is important, but you can't stifle all statements that might lead to violence, just like Madison talked about in Federalist 10. You can't stifle factions as a way of you can't stifle people's views. You can't eliminate factions as a way of trying to deal with the potential problems of factions. Well, you can't stifle dissent. You can't stifle free speech just because they might lead to violence or other sorts of problems. So the Brandenburg test is deliberately very speech protective because the court says we don't want the government to be able to block people from engaging in these important political debates. And if people are involved in political debates, they're going to get carried away. And if we allow the government to come in and suppress speech whenever someone gets carried away and starts to use violent imagery, then we're going to have people who are too worried about the government coming in and stopping speech, and we're not going to get the fundamental necessary advantages that come from dissent. So you get cases like NAACP versus Claiborne Hardware from the civil rights era, where the court says, quote, "Strong and effective extemporaneous rhetoric cannot be nicely channeled in purely dulcet phrases. An advocate must be free to stimulate his audience with spontaneous and emotional appeals for unity and action in a common cause." Result in that case was protecting a speaker's statements calling for boycott violators to have their necks broken because there wasn't any likelihood of imminent lawless violence from the speech. There was maybe one sort of incident of violence that occurred within a month or two of the speech, but nothing imminent, and there was no showing that immediate violence was intended. The court says that speech, even though it stirs people to anger, stirs people to violence, the court says that that's constitutionally protected. Well, what do we have nowadays? What do we have now in an age where, according to a Pew Research poll last fall, 85% of Americans think that political violence is increasing? And frankly, it would be hard to conclude otherwise. With 2 assassination attempts on President Trump, 1 assassination attempt on Justice Kavanaugh, the attack on Speaker Pelosi's husband, attacks on Congressman Scalise and Gifford, the assassination of Charlie Kirk, it seems like political violence is a tremendous problem. So one might think, well, what would our responsible leaders do in response to such an outbreak of violence? Hope that our leaders would tell us to calm things down, to treat the other side with respect, say that they may disagree with us on certain kinds of issues, but they're important people, they're worthy of listening to, we should treat their arguments with the respect they deserve. Well, we get that. I think you know whether we get that or not. We don't get that. President Trump recently, after losing the tariff case, called Supreme Court justices, quote, "very unpatriotic and disloyal to the Constitution." Quote, "an embarrassment to their families." Senator Schumer says, Justices Gorsuch and Kavanaugh, quote, released the whirlwind and will pay the price. It's almost something we don't even notice anymore that President Trump is routinely called a fascist and a threat to democracy, along with the extreme MAGA Republicans, to use the phrase that President Biden used all the time. Immediately after one of the assassination attempts on President Trump, both Vice President Harris and now Vice President Vance called each other disloyal. Harris said that Vance would be loyal only to Trump, not to our country. Vance turned around and said, there is no greater sign of disloyalty to this country than what Kamala Harris has done at our southern border. ICE agents are routinely referred to as Gestapo, terrorists, terrorizing people, secret police, racists. Trump calls members of his own party, including Marjorie Taylor Greene, a traitor. Steve Bannon, former significant advisor to the president, has suggested, I'd put the heads of Anthony Fauci and Christopher Wray on pikes as a warning to federal bureaucrats to get with the program. The vice mayor of a town in Los Angeles County has called on Los Angeles gangs to defend their territory, quote, now that your hood's being invaded by the biggest gang there is, that is the federal government. Trump has referred to the press as the enemy of the people. Vandalism of Teslas was a reasonably common form of protest at people who didn't like the role that Elon Musk was playing in the government. And it goes on. Maxine Waters, member of Congress, told supporters to harass and create a crowd around cabinet officials in public places. Quote, and you push back on them and you tell them they're not welcome anymore anywhere. Even if these statements are constitutionally protected, and I think almost all, if not all of them, clearly are under the Brandenburg test, they're profoundly harmful. In a country of 335 million people, there are bound to be some people who respond to these kinds of statements with violence, even if violence isn't intended. Even if, say, think back to the January 6th problem, even if President Trump didn't want his supporters to riot at the Capitol, surely it was foreseeable that some of them would take his words and take them in that kind of direction, just like it's foreseeable that some of the supposedly leaders of our country would say certain things, would characterize the other side in such a way as to lead predictably to attacks on Trump, Kavanaugh, Scalise, Gifford, Pelosi, etc. Furthermore, so far it's I've addressed calls for violence or references to violence, suggestions that violence may be appropriate. I'd say the problem is even deeper. Even if we get rid of that, there's still a problem that politicians should be responding to violence in the public in a way that discourages it, rather than identifies the political violence as a kind of political opportunity for themselves. And it seems to me like that's what's going on, that either you have people who are saying, well, there's this political violence, I can use this to my own advantage. Yeah, maybe I'll be forced to say that it's a bad thing that the United Healthcare CEO was killed in New York City. But I can say, see how that indicates that so many people are upset with the healthcare system, and we should move in that kind of policy direction. Or the Black Lives Matter protests. Yes, they resulted in the deaths of 19 people at least, caused $1 billion in property damage. But it shows there's a whole lot of dissatisfaction with this sort of policy area, and let's use this unrest to advance a certain policy goal that I had from the beginning. Too many politicians not only fail to condemn this kind of violence, but seems to me encourage or celebrate it. In fact, sometimes literally celebrating it. The Los Angeles mayor called the anti-ICE protests like a, quote, Lakers championship. Soon-to-be Speaker Jeffries referred to encouraged people to fight in the streets. Trump pardoned the January 6th rioters, calling them political prisoners and suggesting thereby, it seems to me, that violence is an acceptable form of political protest, at least if you're on the right side. The wife of former vice presidential nominee Tim Walz talked about how she opened the windows on their house so that she could smell the burning tires from the Minneapolis riots. Senator Mullins, who is now the nominee to become the Secretary of Homeland Security, referring to the attack on Senator Rand Paul, said he understood why someone would attack Senator Paul. And we have various statements before he became mayor, the mayor of New York City, saying things like globalize the intifada. And various people around this country have expressed support for the murderous Hamas regime in the Middle East. I find these all very distressing. And so the question is sort of what to do about it, or more particularly, should we do more about it? I think we should, in that insofar as these activities are not constitutionally protected, insofar as they are actual violence, insofar as they meet the Brandenburg Standard, I don't think we should tolerate it. I don't think we should tolerate an autonomous zone in Seattle. I don't think we should tolerate people who decide to occupy Wall Street. I don't think we should tolerate people who commit other kinds of acts of violence. But I don't think that we should crack down on dissent. I don't think that we should crack down, change the Brandenburg Standard. Because, as I try to tell my students in the First Amendment class, the biggest lesson of First Amendment law, the biggest conflict in First Amendment doctrine, centers not on whether speech is harmful or good. There are plenty of examples of speech that's harmful, speech that's false, speech that leads to bad consequences, speech that hurts people's feelings, speech that threatens political stability. The question is whether government involvement would make that problem even worse. And for all the problems that free speech leads to, legitimate free speech, not violence, not speech that's constitutionally unprotected, but speech that talks in violent terms of something maybe far off. For all the problems that that causes, and I think that those are serious, I am frankly more worried about giving government the power to come in and identify certain speech as dangerous and to have the government come in and stop the speech on that basis. I'm sorry that this wasn't more cheery talk. But I do very much appreciate the opportunity to speak to you. And thank you again very much for coming.
Our next speaker is Lauren Gailey. She is an assistant professor of law at the Thomas R. Klein School of Law at Duquesne University. She attended Duquesne Law, where she graduated at the top of her class. After law school, she held several federal clerkships and worked for a top District of Columbia firm specializing in appellate practice. She has published several articles already on the First Amendment's press clause and on media and defamation law. Professor Gailey.
Thank you, Widener, for inviting me here. Thanks to Kiera and her law review colleagues for their astounding professionalism. I'm so impressed. And thanks to all of you for spending this first day of spring in here with us. And I think it'll be raining by the time we leave too, so, oh, well, we can't give you the sun back, but maybe I can give you a little bit more hope than you have now after Professor Dimino's presentation. just even a little bit is an improvement. I was sitting over there physically sinking into the chair. The theme of this symposium is dissent, and when I first heard it, my initial impulse was to ask for clarification. Which version of dissent did the law review want me to talk about? The colloquial one, meaning disagreement, protest, things like that, or the kind that Professor Oldfather had told us about earlier, so a court opinion for the losing side. But I'm a First Amendment scholar, and it hit me that in my field, the two meanings of dissent are related. Dissents can affect the right to dissent. And Judge Mehalchick discussed the mechanics of this. The dissenting judge puts a stake in the ground in the hopes that their view will eventually become the law. For better, Dean Cummings mentioned Justice Harlan's dissent in Plessy, and sometimes for worse. A few ideas that have origins in dissents are keeping me up at night right now. Will New York Times versus Sullivan go away? And with it, heightened protections from libel? What does the future hold for implied privacy rights? The freedom to be let alone to make important decisions in our personal lives without the government stepping in and interfering. And then there's the one I'm going to talk about today. Will the history and tradition test which I haven't pulled up my PowerPoint, you should be able to see shortly. Magic. History and tradition. If I can square this up. All right. I trust that's what folks are seeing at home too. Well, this history and tradition test that the Roberts Court is so enthralled by right now destroy a century's worth of First Amendment precedent. And I am not the only one who is worried about this at 3 a.m. Trust me, I'm in good company, including our keynote speaker, always the first and the best among us, who saw this coming 30 plus years ago. And he was a prophet, because history and tradition has now entered the mainstream. And it's creeping into the Bill of Rights, including the First Amendment. And that's why I'm calling this article The Sum of Their Fears. Borrowed that phrase from Winston Churchill. Nice to have an excuse to show that incredible, incredible portrait. It captured my mood, which looks a lot like that, as I explore a few scary questions in this piece. Is history and tradition about to become the First Amendment test? And if it does, can the body of law as we know it, those expansive and robust speech rights that are the envy of the world, can they survive? Having now dug into those questions, though, I actually feel somewhat better. And I hope you will too in about 15 minutes. History and tradition is a constitutional test that comes out of the same ideological movement as originalism does. And we've seen the Roberts Court use it in 3 contexts now. The Second Amendment, where it became the official test in Bruin, and 2 different 14th Amendment doctrines, incorporation and substantive due process. And those 2 tests fused together in Dobbs. These cases were actually decided within 1 day of each other in 2022. But the tests are different. The latter asks whether there is a right. The former asks whether a regulation comports with an existing right. But as I see it, these tests are interrelated. Again, these opinions came down on back-to-back days, and I think you don't get one without the other. What they have in common is a requirement of a long and continuous historical pedigree. Why require that? Why base rights on history and tradition? Well, to put guardrails around judicial decision-making. Some people thought that the Warren Court was too ideological, too outcome-driven. Those people wanted to use history as an objective basis for a more consistent methodology that didn't leave room for judges' personal preferences and biases to seep in. Query whether this works in practice. History can in fact be quite subjective. I don't know about you, but I don't know what's going on with events that are happening today. Literally, I don't know. And so on a limited historical record, that problem becomes amplified. And you can cherry pick evidence to come up with a version that aligns with your own preferences. But whatever the merits of the history and tradition approach, the fact is, justices who like this approach are now a majority of the Supreme Court, and many of them aren't much older than me. So, how did we get here? The history and tradition test is a creature of the 14th Amendment, specifically the Due Process Clause of the 14th Amendment. And this matters because it raises unique issues. The 14th Amendment poses serious federalism concerns. No state shall. That is a big deal, especially during Reconstruction when it was enacted. The Bill of Rights did not originally apply to the states. So the 14th Amendment solved that problem through the process called incorporation. The phrase due process of law has been read to incorporate fundamental rights from the Bill of Rights, almost all of them at this point. And because the 14th Amendment applies to the states, so then do those rights. But these aren't the only rights that find a home in the 14th Amendment. For a long time, the court has read the word liberty as a repository for other rights that aren't spelled out in the text, like those privacy rights I mentioned earlier, procreation, marriage, parenting, family structure. This doctrine is called substantive due process, meaning substantive rights implied by the phrase due process of law. Using terms like liberty and due process of law as bases for rights can give judges a lot of leeway to get creative in finding rights. And this sounds great, but taken too far, there be dragons. If everything is a fundamental right, what room is left for states to exercise their police powers in a system in which they purport to be sovereign? History and tradition was intended to be a limiting principle on this. These rights had to have a historical basis, and people had to rely on them for a really long time. That's why history and tradition grew out of these 14th Amendment doctrines. The earliest cases that you see behind me were basically proto-incorporation issues before the doctrine found its feet. But it took the court a long time to come up with an incorporation test. Justice Frankfurter, in his typically Byzantine mannerism, proposed a convoluted one in Adamson in a concurrence that really didn't take off. It was something about the notion of justice of the English-speaking peoples. I can't imagine why people didn't go for that. But 20 years later, in Duncan versus Louisiana, the court settles on a test and says to be incorporated, A right has to be fundamental to the American scheme of justice. And history would, of course, play a part in that. But then, the other Justice Harlan, the great dissenter of the Warren Court, the original great dissenter's grandson, writes a dissent saying tradition should factor in too. But then, in a more recent incorporation case, this is McDonald versus Chicago, the court gave tradition a key role in the test. McDonald was the gun case where the Second Amendment ended up being incorporated, and Justice Alito officially brought history and tradition into the incorporation test. He said, "We must decide whether the right to keep and bear arms is fundamental to our scheme of ordered liberty, or, as we have said in a related context, whether this right is deeply rooted in this nation's history and tradition." What did he mean by fundamental or deeply rooted in history and tradition? Would either one suffice to find a right? Or was he defining fundamental rights in terms of history and tradition? And what was this related context that he got it from? Well, the answer to that question was substantive due process. And that was the other line of cases where a Harlan dissent played a very important role. In the early 1960s, the Warren Court was starting to use the substantive due process theory as a basis for these privacy rights. Poe versus Ullman was a challenge to a contraceptive ban, and the court dismissed it on jurisdictional grounds, but Justice Harlan dissented. He would have struck the ban down on its merits. Relevant to our purposes, he said the balance between history and order is based on the traditions from which it developed, as well as the traditions from which it broke. And here, he would have used tradition to find a right to contraception, or at least the broader right to be free from dumb and invasive laws more generally. So in Moore versus City of East Cleveland, the court takes Justice Harlan up on this approach and uses tradition as a basis for the right to structure your family as you see fit. But then, the court starts to use history, and especially tradition, to restrict rights rather than to use them as a foothold. Washington versus Glucksberg was the tipping point. This was a physician-assisted suicide case from 1997. The court refused to recognize the right to die with dignity, largely because the tradition previously had been to criminalize suicide. Now, in Obergefell in 2015, the court did find a substantive due process right, the right to marry a person of the same sex, but not on tradition grounds. Tradition played a key role in all of the dissents, including dissents from Justices Alito and Thomas. They pointed to the traditional definition of marriage and the tradition of respect for people's religious beliefs that proscribed same-sex marriage. But remember, that was the losing argument there. So we've got these two lines of cases where history and tradition is percolating. Both are under the 14th Amendment, and tradition is apparently just one path to arrive at a fundamental right. And then, on back-to-back days in 2022, there's a supernova, a big bang. History and tradition squishes these doctrines together and then explodes its confines. Two things happened on those days. In Dobbs, Justice Alito fused the incorporation and substantive due process tests into one, confirmed that fundamental rights are defined in terms of whether there is a history and tradition of recognition of that right. So history and tradition is now an element of the test for both incorporated rights and substantive due process rights. The other thing that happened was that history and tradition escaped the lab of the 14th Amendment and jumped directly into the Bill of Rights in Bruin. It was a Second Amendment case, and I think that's no coincidence. Remember McDonald? That was an incorporation case, but it was also a gun case. And I think Justice Thomas conflated the two in Bruin. And he made history and tradition the main component of the test for the Second Amendment itself. Now, normally, when a fundamental right's infringed, courts apply heightened judicial scrutiny. Not here. When a law infringes the Second Amendment, you look to see if the law comports with history and tradition. You're looking for a historical analog from the past. But then Justice Thomas went on to say in the next sentence, this is just like how we approach the First Amendment. And yeah, I see looks on faces around the room that are quite right. This is not like the First Amendment. So imagine my surprise when we see history in a First Amendment case, Elster. This was a challenge to the ban on trademarking the names of living people. Which living person? Remember this? The court was unanimous that no, you can't trademark people's names. And the rationale for this case is basically, if it ain't broke, don't fix it. But Justice Thomas, who happened to be writing this opinion, framed it in terms of history and tradition. So was Elster a weird throwaway trademark case? Or is history and tradition coming for the First Amendment? Now, obviously, it's very different from the current test. For Thomas, history and tradition starts with a textualist reading of the provision at issue, but as Dean Chemerinsky just told us, the court has never read the First Amendment literally. Congress doesn't mean Congress, no law doesn't mean no law, and speech certainly doesn't mean speech. Aside from a few categories, like the ones that Professor Chauvin mentioned, incitement, true threats, an infringement on speech gets heightened scrutiny. Regulations based on content, strict scrutiny. Content neutral, intermediate. That's the typical First Amendment test, determining what level of scrutiny you're going to apply. And that is the very approach the court rejected in Bruin. Bruin says, don't apply scrutiny. We're looking for historical analogs. And then we have the body of First Amendment law that's basically become a legal code for all of these specific situations. What if it's a government employee speaking? What if the speech takes place in a public school? There are rules for all of this. Rules that are arguably atextual and ahistorical. So you see why it's concerning to scholars that the First Amendment could be subjected to a historical test. Dean Chemerinsky was prescient in 1993 that this is the way this court was going. And his major theme was that the First Amendment is deliberately anti-majoritarian. This means it's going to run counter to tradition in most cases. But back then, this threat was still hypothetical. Bruin and Dobbs made it real. And scholars started to get scared. Clay Calvert and Mary Rose Papandrea, two very serious scholars, laid out a worst-case scenario in which incorporation itself could go away. Most existing free expression jurisprudence would be undermined. The First Amendment would be limited to its plain text in a way that would carve out large swaths of the rights that we enjoy today. Expressive conduct wouldn't be protected. There would be no right of access to information. Nothing beyond literal speech would be covered. And it might even exclude the use of modern technology for that speech. This is pretty gloomy. We're in good company so far.
I'm going to say not gloomy enough.
Yeah. See if I can pull us back here. I see a couple reasons for hope. First, how likely is this to actually happen? I'm happy to report that nobody on the Supreme Court actually seems to want to overhaul the First Amendment. Justice Thomas actually didn't think he was displacing anything. Now, whether he was right is another thing. But Justice Barrett, with the 4 liberal justices, pointed out in Elster, like, whoa, this is not how we analyze First Amendment cases. So a fellow originalist is putting on the brakes. Justice Kavanaugh, another one, has said elsewhere that Bruin didn't affect the use of scrutiny levels in other areas. This is what various justices have said, but more illustrative is what the court has done. In 2024, in Net Choice, the court had a chance to adopt history and tradition and didn't take it. This was one about the Texas law that tried to restrict social media content moderation. The Fifth Circuit had upheld it on history and tradition grounds. The Supreme Court, though, did not take the bait. It adhered to its own precedents, recognized that moderation was protected, and sent it back down for the usual First Amendment analysis. And then in TikTok, a year ago, The case that was basically about which level of scrutiny are we going with. Nobody seemed to have any appetite to get rid of scrutiny entirely. So maybe history and tradition isn't an immediate threat, but what if it were? Is a thought experiment worth conducting? And here, I'm finding that some areas of First Amendment law would hold up surprisingly well. Press rights. People forget that there's another clause right there in the text. The colonists weren't happy with just the rule against prior restraints, which is basically all they got from the crown. They wanted more than that, and so they demanded it. At the founding, there was a very broad conception of what press meant, so what activities qualified, who was protected, and this country's had a strong tradition of press freedom for a very long time. Obscenity, not regulated at all at the founding. That didn't happen until Victorian times, and even then it was selectively enforced. Even libel. Legend has it that New York Times versus Sullivan liberated us from the dark ages of strict liability in libel cases. But Alabama's approach in that case was actually the minority approach, even at that time. And the Sullivan decision was based on a historical analysis. Accusing the court of being ahistorical is completely unfair. Now, this isn't all wine and roses. I don't know what's going to happen to public forum theory. Incitement, Brandenburg, which Professor Dimino was just talking about, that's probably in trouble. Indecent language, I think that's trouble there too. But the point is that the situation on the ground isn't as bad as it might look at first glance. Litigators have tools that they can use to try to preserve these rights, even if the worst should happen. Don't forget, this is a text, history, and tradition test. And yeah, the text could be confining in some ways, but in others, the text-to-speech clause is arguably absolute. So use those favorable aspects to your advantage. Second, break up these elements. Why confine ourselves to the Bruin approach until directed otherwise? This text and then history and tradition together. Decouple these parts. The plain text cannot be overridden by history and tradition. And then why lump history and tradition together? Sometimes there might not be a history of a right, but there is a tradition, and vice versa. So argue it. Argue for a higher level of generality. Reva Siegel at Yale has made this point too. The more generally you define the right, the broader its scope. And Justice Harlan's Poe dissent, he suggested the freedom from all substantial arbitrary impositions and purposeless restraints. You don't have to go nearly that far. New York Times versus Sullivan's a great example. This wasn't a case about Alabama libel law. It was a case about the right to criticize the government. And we've got a far longer, prouder tradition of that in this country. And finally, history's open to interpretation. Both sides can pick cherries. Why should we civil libertarians fight by Marquis of Queensberry rules when the other side goes bare knuckle? I stole that line from Justice Scalia, so there. Pick your best historical evidence that supports your argument for broader rights and throw it in your brief. That brings us back to the sum of their fears. I selected the quote in the spirit of pessimism. I just wanted those memorable words, even if they were out of context. But I've come to realize that this situation is actually closer to the true spirit of the quote in its full context. Churchill was warning against pessimism. Military leaders, because they've seen the worst, fear the worst. If they're in a bubble, they validate and reinforce each other's fears, and so they can be too conservative in their actions. So too here. Supporters of expressive rights need to be mindful of potential threats, but also see opportunities to defend those rights. This country was founded on dissent, and there is no reason that that long history and tradition needs to end anytime soon. So thank you very much for your attention, and I look forward to your questions and feedback. That's us, by the way.
Alan Garfield, our final speaker, is a distinguished professor at Delaware Law School, our former partner law school. He previously served as the H. Albert Young Fellow in Constitutional Law. He's a graduate of UCLA Law School, and he too has published numerous articles on free speech and copyright issues. Most recently, he co-authored an excellent casebook on First Amendment law. His co-author was former Delaware Dean Rodney Smalla. Professor Garfield, too, has won awards for his teaching and scholarship. I actually remember Professor Garfield for about 20 years ago at the AALS when you were running the section and you brought Daniel Ellsberg in. And I thought that was a very thoughtful addition to a discussion. We actually heard the real facts about the leaking of the Pentagon Papers, and it gave us quite a different framework for discussion. Professor Garfield.
Thank you. And I've got to get the my PowerPoint pulled up. This one. Let's see, can I start the show this way? How do I start the show from the below? I can't.
The little podium icon. This little guy here.
Ah, thank you. And let's see if this works. On it. Okay, thank you very much. If you don't mind, I might keep you a little bit overboard just so I can get through this. Thank you. First of all, again, I'll just say quickly my appreciation to Kiera and everybody else for inviting me here as professors who are in Commonwealth who are long in the tooth know that years ago the Delaware and the Commonwealth faculty used to get together at least twice a year for meetings, and so this is kind of a reunion for me with some old friends. So it just adds to the pleasure. So I am, the topic was the evolution of dissent in this country for 250 years. That's a broad topic, but I thought I'd talk a little bit about, going back to the earlier days, what the First Amendment was a reaction to, and then go to contemporary times. And if there's an overriding theme, it might be that, everything's old is new again. So not entirely, of course. But let's get started. Okay, this is the only PowerPoint slide that has Thomas Paine and Jimmy Kimmel on it, I'll point out. So, and some of what I'm going to say is going to overlap with Chemerinsky, and this actually overlaps with what Professor Dimino was saying. Holmes has this wonderful line in his famous Abrams Dissent that, the logical thing for people in power to do is to suppress criticism that undermines their power, that shows embarrassing things about the the people in power. Persecution for the expression of opinions, he says, seems to me perfectly logical. And you have to realize that the history of the world is not a history of protecting freedom of speech. It's a history of monarchs and religious establishments and politburos and on, suppressing speech they don't like. That's the history of the world. Freedom of speech is the exception, and it's not just in history. It's today. The Varieties of Democracy has an annual report. They say that 75% of the world's population live in one form or another of autocracy, that do not have robust democratic rights or freedom of speech. Just start with China. India under Modi has a lot of repression. Think of Russia, Iran, Saudi Arabia. We are the exception. He actually says liberal democracies have become the least common regime in the world. Okay. So the logical thing to do is to suppress speech. Now, let's talk about what happened back then. Let's go to King George III. Because when we talk about the First Amendment, we're talking about what it was a reaction to, okay, in part. And anytime there's a new technology, anytime there's way for speech to spread broadly, that's a threat to people in power because, and as Chemerinsky said, one of the greatest protections, perhaps, of our freedoms is that it's almost impossible today to control the internet, right? And when the printing press came to England, that was a threat to the people in power, that they wanted to control the people's access to what's being said, just like China today has the great firewall, right? Not the Great Wall, but the Great Firewall. So one approach to try to, that people in power try to do, is to stop the speech before it occurs, to have prior restraints on speech. And in England, the way that was manifested was with the English licensing law, that you needed a license, from the government to be able to publish. Right? That's the ideal way to control what kinds of things are published. Now, even then, there was dissenting voices. Famously, John Milton wrote, and he published without a license, Areopagitica, where he made the argument for an open marketplace of ideas. Let truth and falsehood grapple. Whoever knew truth put to the worse in a free and open encounter. Of course, do you think that truth always prevails in a free and open encounter in the marketplace? Might depend on who the consumers are, and as Kiera said at the beginning, how well they use their freedom in trying to educate themselves and inform themselves. But still, okay? Before our independence, the licensing regime had already lapsed in England, and in fact, the notion of the impropriety of prior restraints was already built into the English tradition. In Blackstone's commentaries on the English law, he says, the liberty of the press consists in laying no previous restraints upon publication. Okay, so already that was built into it, and historians all seem to agree that the First Amendment, if it meant anything, was that there should not be prior restraints on speech. And that's become canonized in our law, most famously when the government tried to stop the publication of the Pentagon Papers, right? Confidential material that Daniel Ellsberg, who was just referring to Daniel, there you were, right? The guy who I invited to the AALS, took a copy out that gave to the New York Times and the Washington Post. It showed that 4 presidents, Democrats and Republicans, had systematically lied to the public, and the government wanted to enjoin the publication. And the court has, this famous line about any system of prior restraints of expression comes to this court bearing a heavy presumption against its constitutional validity. So you might say, all right, problem solved, right? That kind of problem. We don't have to worry about it anymore. The law has fixed it. Now, the other major vehicle that they used in jolly old England to try and suppress criticism of government was seditious libel, criticism of the government. And in fact, even truthful criticism was punishable. It was thought truthful was even worse because you couldn't refute that. There's the line, the greater the truth, the greater the libel. And the notion is governments have to be protected from criticism. One of the justices, Lord Chief Justice John Holt, it is very necessary for every government that the people should have a good opinion of it. So we should suppress criticism of government. And even in Blackstone's commentaries, while he says freedom of the press means no prior restraints, suggested that after publication, speech can be punished. To punish any dangerous or offensive writing, which when published, shall on fair and impartial trial be judged to have a pernicious tendency is necessary for the preservation of peace and order, of government and religion, the only solid foundations of civil liberty. One of the things historians debated about in what was the intent of the First Amendment, there was agreement that it meant to preclude prior restraints, but there was disagreement about whether it was meant to forbid the law of seditious libel. And indeed, as Chemerinsky said, 7 years after they did the First Amendment, there was the Sedition Act of 1798. Here's the, Matthew Lyon, the first one arrested under that law, which might make you wonder if they intended to get rid of seditious libel. But as Chemerinsky also pointed out, in the 1960s in New York Times versus Sullivan, which you've all probably studied, not only did the court say, although the Sedition Act was never tested in this court, the attack upon its validity has carried the day in history. But it's not just the court of history. They put in doctrine to try and limit the ability for a public official and later public figures to sue for defamation. Created a very high standard, which, as you were just talking about, some judges are talking about maybe we should abandon that standard, right? But so here again, our jurisprudence has built in these safeguards against the abuse of defamation actions, against this presumption against prior restraints. So you might say, mission accomplished, right? We're sitting pretty. Well, now let's talk about, that was then. Let's talk about now. Okay? Now, this image itself says something about at least the current president's thoughts about respect for protest, right? And I think most presidents would realize that's a breaking a norm. But let's talk about what's going on. Stopping speech before it occurs. It's still true. You don't need a license to publish a book. Mary Trump could publish a book critical of her uncle. Stephen Colbert and Jimmy Kimmel can criticize the president. Lawrence O'Donnell, every single night of the week, could say he's a sociopath. Right? That's the good thing. We still have that robustness. People don't need a license to punish. But there are a lot of things people do need from the government, okay? And companies need approval of mergers. Broadcasters need FCC licenses. Universities need research grants. Foreign students need visas. Lawyers need access to courthouses, and it goes on and on. And one of the more insidious things, I think, of the current administration is they have learned that to wield the resources of the federal government in a way to pressure people, to pressure dissent, to silence things they don't like. It's unconstitutional in most instances, and the lower courts have generally got it right. But let's think about the implications of that. Let's start with universities. As Dean Chemerinsky was saying, there to be robust marketplaces of ideas. That's the model, right? Well, one of, the federal government sent a letter to Harvard University that if the federal government, we give millions, if not billions of dollars to these universities, a lot of which seems like it's for science research. And that's what Congress appropriated it for. But for the administration to say, hey, if you want that money, and here, for the conditions they had things like the university must cease all preferences based on race and religion. And there are arguments certainly that some things could violate the civil rights laws. Some things with, DEI, to simply discuss history, discuss inclusion is not a problem. The university, but most importantly, I'll focus on the last one. The university must commission an external party to audit the student body, faculty, and staff for viewpoint diversity. I've got no problem with people saying there's not enough viewpoint diversity in universities. I have no problem with people saying universities in some way have become too woke in some instances. They could use some ballast, but is this the way to accomplish it, to have, an external audit of the student body, faculty, and staff? Now, if you're Harvard, if you have the resources of Harvard, you could fight it. And it did, and they won. This is the judge. The rights protected by the First Amendment include the right to manage an academic community and evaluate teaching and scholarship free from governmental interference. If academic freedom means anything, it means that. Defendant's April 11th letter on its face was directed at these core freedoms. So you say, great. But many other universities cave to the government. I mean, think about it. Okay? If you're about to lose $300 million in science funding, and Congress allocated it for that, but the university is withholding it because they don't like your DEI policies, or they don't like your Middle East department, they think it violates the law to teach critical race studies or critical gender studies, putting aside actual discrimination in hiring. How many universities could afford to fight that, and go without that funding? So it's not surprising. And don't forget the trickle-down effect of this, right? There's a lot of universities that don't have anywhere near the kind of resources that these universities have. And a lot of them, I think it could fairly be looked at their curriculum, looked at their DEI policies, because they did not want to get on the radar screen. Right? Let's take another example, law firms. Okay. Trump, one of many executive orders, this one against the risk posed by Perkins Coie, who, among other things, had the nerve to do things like represent Hillary Clinton earlier, and other parties that Trump didn't like. The order was saying to respond to the risk, the immediate suspension of security clearances for their lawyers, limiting access of the firm employees to federal government buildings. Government will not work with any contractors who use Perkins Coie. Another way you could abridge the freedom of, the First Amendment is, litigation is speech. And retaliating against people because you don't like the viewpoint they're expressing, even in their litigation, is a First Amendment violation. Perkins Coie fought it, here's the judge, in a cringeworthy twist on the theatrical phrase, "let's kill all the lawyers." The executive order takes the approach of, let's kill all the lawyers I don't like, sending the clear message, lawyers must stick to the party line. As Chemerinsky says, we still got good doctrine out there. But don't forget, and this is a short list, of the law firms that cut a deal, right, with the administration, perhaps agreeing to litigate on things they don't want to agree with, cutting back on their DEI policies. Regardless of whether there's any argument that it violates the civil rights law, it just depends on what the action is. But, the reality is, of course we bar prior restraints, right? But if you are a law firm and you've got a lot of government clients, right? And those clients are not going to want to work with your law firm if they know the administration doesn't like their law firm because it's going to spill over for them. And you got a lot of employees, right? It's easy. The chilling effect could be real, notwithstanding the precedent. You following me? We talked about the FCC. You need broadcast license. Now, as Chemerinsky, the law talks about you're supposed to, you have to have licensing because if anybody could broadcast on any signal they want, we'd have static. So you need to get licenses for different geographical areas to avoid that. That makes sense. And they talk about using the license in the public interest. But it is not a license for the head of the FCC or the FCC to punish and deny licenses because they don't like the viewpoint expressed, whether it's how they cover the war. That is exactly what Putin did in Russia when they invaded Ukraine, is they punished, some of the few independent press that wouldn't cover the war the way he wanted it to be covered. And, but still, there's impacts after the Jimmy Kimmel remark on Charlie Kirk, and he says, these companies got to find a way to take action on Kimmel, or there's going to be additional work for the FCC ahead. I mean, remember, Kimmel was suspended, right? Temporarily. It was public pressure. I think that really brought him back. There was a recent thing, there's the equal time. If you have a candidate running from office, you have to have the other candidates. It's usually historically been thought for years now that it doesn't apply to news and late night talk shows, but he was suggesting it could be a problem for Colbert having someone running in Texas, and they didn't show it. It was put online, got probably more views than it ever would have because of the press. Companies also need from the government approval for mergers. And all sorts of other things, contracts, other things. So, I mean, you just think about it, going back to Brendan Carr here and ABC. So, ABC, ABC depends on its affiliates who carry the ABC network, right? Like Nexstar and Sinclair. Nexstar depends on the FCC granting them permission to merge with other companies. And both of these companies were trying to get the FCC to repeal a rule about what percentage of a market they're allowed to own, right? So if Brendan Carr, is irritated by Jimmy Kimmel, right? And ABC is worried about Nexstar and Sinclair because that's their bread. Those are the people who cut their networks. Well, Jimmy Kimmel may not count for much in comparison to the importance of those mergers or taking place. You get the idea? I mean, it's a similar thing. There's good defamation law out there by the Supreme Court. Trump brought a crazy defamation action that no media lawyer would say would be successful against ABC for a remark George Stephanopoulos made. But they settled for millions of dollars because, they want other things from the government. This is part of the media being media outlets, even large ones, being just small parts of conglomerates. The same kind of thing when Paramount wanted to merge with Skydance, which was owned by Larry Ellison. And there was a lawsuit against 60 Minutes saying they deceptively edited, a interview with Kamala Harris that, again, I don't think any media lawyer would suggest would be successful. But, Paramount's worried about getting permission for bigger things from the government. This is giving them $50 million, settling it for $15 million, whatever, is nothing, right? And some would say it might have led to terminating Colbert, who was obviously a thorn in the side. I mean, we have to start wondering in this world about, is there a problem of having media controlled by billionaires and also by these large conglomerates? Somebody like Jeff Bezos, who owns the Washington Post, he may be more concerned of getting contracts to provide cloud computing to the government or rocket ships to the government to compete with Elon Musk, that the Washington Post is peanuts to him, right? Although he did then say they couldn't put out an endorsement for who was running for president. They changed their opinion page policy. I mean, because maybe there's other things he's concerned about. Same thing with Elon Musk, right? He's got contracts for Starlink or SpaceX or whatever, right? what happens when the media is controlled by large companies that have all sorts of other interests with the government? You know, if we need them to protect the First Amendment rights, but they don't want to irritate the government because they're making a lot more money somewhere else. Let's talk about punishing speech after it occurs. Okay? We still have those robust First Amendment protections against defamation actions. But a government bent on punishing its critics has a lot of tools, has lots of tools in its tool chest. How about prosecuting people you don't like? I mean, here's the Trump tweet about, you know, screaming, you know, to the Attorney General, what about Comey and Adam Shifty Schiff and Letitia? Justice must be served. And sure enough, you know, indictments were brought. Now, mind you, the courts, as you know, have pushed back on a lot of these. But, you know, how many people could endure the cost, the anxiety, the stress of even the threat of prosecution, right? What kind of chilling effect? Cutting, you know, when Senator Marquette, not in uniform, said military personnel should refuse to follow illegal orders, and, you know, Trump, this is seditious, traitorous, whatever, punishable by death, that, you know, that, again, you know, taking away someone's benefits because you don't like what they're saying. Now a judge, again, pushed back. Rather than trying to shrink the First Amendment liberties of retired servicemen, Hegseth might reflect and be grateful for the wisdom and expertise that retired service members have brought to public discussions. Now, Senator Kelly, Harvard University, maybe Perkins Coie, have the resources to push back, okay? But think of all the people who don't. I mean, there was an article in the Times not too long ago how ICE, you know, uses their phones, captures protesters' face, you know, immediately could find out who they are and say, I know your name, I know where you live, right? What is the chilling effect of something like that? And are they going to go spend the money to hire lawyers and do that? There will be some lawyers who will volunteer to do that. But you could see the chilling effect. Is it possible to protect the right to dissent? Well, first of all, to take you through people power, in part, is I think why Jimmy Kimmel came back on the air. The pushback was hard. Going back to Minneapolis, the actions of people peacefully, they should not be interfering, they should not be, you know, using any kind of violence, but peacefully protesting, and filming is a way of providing some kind of protection. You know, ultimately, you know, my favorite quote in First Amendment is from Learned Hand. You know, it's broader than the First Amendment, who says, people think that what protects their liberties are constitutions and laws and judges. And he says, believe me, that is a false hope. Now here, liberty lies in the hearts of men and women. When it dies there, no constitution, no judge, no law, no judge can save it. So ultimately, I think what we have to ask ourselves is, we've been given this freedom. How are we going to use it, right? And this is an incredibly challenging time for the marketplace of ideas. It's good, as Chemerinsky said, that there's a million different outlets out there. It also means that everybody goes into their silo and never challenges themselves to think outside the box, right? We are going to be inundated with AI-generated fake videos and fake text, okay? And the marketplace idea depends on consumers being good consumers. And one, you would think that would mean we have to have an educational system that educates people to do that, and quality education, you'd hope. Do we live up to that? And do people in the marketplace of ideas spend their time, or are they willing to pay for reliable resources? Do they spend their time searching it out? Or are they, and as the algorithms suggest, look for heat instead of light, right? And as Chemerinsky also said, the internet, you could say it's great. Everybody has access to publish to the multitude. But how do people use that power? You know, the Pew study, which was quoted earlier, talks about the incredible amount of harassment that goes on the internet. You know, it brings out the best of us, it brings out the worst. So, I mean, I guess I will just end picking up on Professor Dimino's point in the beginning of, yes, we need robust dissent. Yes, as Chemerinsky said, what you need the First Amendment for is to protect the speech we don't like, we don't want to hear, right? The other we will protect. But it also depends on people taking their freedom seriously and using it wisely and putting the effort to make it work. And it also depends on people abiding by norms, liberal, conservative, whatever, all of the rhetoric about, you know, violence and encouraging violence is totally, you know, totally inappropriate and totally against the whole concept that in a democracy you resolve conflicts through peaceful processes. So I will leave you with that. Thank you for staying over. Sorry.
Thank you. We've gone into overtime, and so we will not be doing questions at this time. You can send your questions to any of us. Their emails are available, or send them to Kiera.